All right, good morning, everyone, and welcome to the Nevada State Board of Cosmetology's board meeting. The time is 9:06 on February 23rd, 2006. I do apologize for running a few minutes behind, but we are going to get started at this time. I'd like to start the meeting off with roll call from our Southern Office board members, please.
Board Member Wold, present.
Board Member Moreno, present.
Board Member Harris, present.
Board Member Detry, present.
Board Member O'Brien, present. Thank you. Can we go to our
Board Member Douglas, present. Board Member Douglas, present.
Thank you, Anita. Sorry. Can we go to our Northern Office now, please, for roll call?
Board Member Jeffers, present.
Thank you. Let's go back down to our Southern Office board staff for roll call.
Steve McDonald, Executive Director, present.
Janie Huggins, Chief Compliance Officer, present.
Bertha Jackson, Chief Operating Officer, present.
Lauren Gossage, Regulatory Compliance Specialist, present.
Joseph Ostunio, Deputy Attorney General.
Todd Weiss, Senior Deputy Attorney General.
Thank you. Do we have any board staff up in the Northern Office present? All right, at this time, we'll get started. The mission of the Nevada State Board of Cosmetology is to protect the public health, safety, and welfare of those that obtain cosmetology-related services through the delivery of quality testing, licensing, inspection, and education services that focuses on consumer protection. At this time, we're going to do comments from the general public. These are for discussion only. The board will entertain comments from the general public for any item that is related to the Nevada State Board of Cosmetology. Members of the public can call into the meeting to make public comments by dialing 1-720-707-2699 and entering 893-8557-0576 for the meeting ID. Comments are limited to 3 minutes or less. No discussion or action can be taken during public comment. Do we have any public comment at this time? I'm not seeing any public comment, so we're going to go ahead with agenda item 3, which is approval of minutes from previous meetings for discussion and possible action. The board is to approve minutes from January 12, 2026 board meeting. Can I have a motion, please?
This is Board Member Harris. I would like to make a motion to approve the minutes for January 12th, 2026.
Board Member Wold, second that motion.
Thank you. All in favor?
Aye.
Aye. Any opposed? All right, motion carries. That brings us to agenda item 4, which are complaints portion of the meeting. I believe we hear, no, sorry. Should we go, not you. Should we go to, we have representative for Q Day Spa. So do we have anybody for Bali right now? We do. Online. Okay. All right. So then we'll just go in order. Okay. Sounds good. All right. So we're going to go in order. So we're going to start our public hearing on complaint number C 2025-0311 for discussion and possible action. The board will conduct a disciplinary hearing regarding the allegations in the complaint filed on January 29, 2026 against respondent Bali Spa, license number S708692, business ID number NV 202327075574. Adam Spencer Dick, owner operator. Upon conclusion of the hearing, possible action includes imposition of discipline. Appearances are Joseph P. Osinio, Deputy Attorney General for the board, and Todd M. Weiss, Senior Deputy Attorney General Counsel to the board. Okay. Do we have a representative for Bali Spa?
Yes, I'm here.
Hi, do you have the ability to turn on your camera, please, so we can get you sworn in?
Absolutely.
Thank you so much.
Great.
Hi, if you can raise your right hand, we'll go ahead and get you sworn in.
I just I
Mr. Dick, you got your right hand raised. Thank you. Do you solemnly swear the testimony you will give today will be the truth and nothing but the truth?
Yes.
Thank you.
Okay, wonderful. At this time, we hear from our Deputy Attorney General, Joseph Esnio. Go ahead.
Good morning, Madam Chair. Thank you for the opportunity to speak today. Give me 1 second. I'm a little. We're doing it. Members of the board, this case is about a business that chose to disregard the rules designed to protect the public. The evidence will show that Valley Spa engaged in unlawful and unethical practices, placing clients at risk and undermining the integrity of the cosmetology profession. At the close of this hearing, we will ask you to enforce the law and hold the spa accountable for its misconduct. Thank you.
Okay, at this time, Mr. Dick, if you'd like to make an opening statement, you have the floor.
Well, not sure how much of these I'm supposed to have. I did do a hearing with you guys before about this.
Excuse me, Mr. Dick, I'm so sorry. You're breaking up a lot and it's hard to hear. Is there possibly for you to come closer to your screen or your mic?
Was that better?
It's a little better. Can you speak a little slower as well? And maybe that'll help with the breakup.
Okay. I can do that.
Yeah, that's better. Thank you.
Okay, I'm not sure what an opening statement's supposed to be, but as far as I'm concerned, I went through a hearing for this, one of these complaints, or at least the soliciting complaint. At the time it happened with the state board. And then I went through it for the massage board, and I relinquished my licenses and closed the business, and I thought it was over because I don't have anything to do with it.
I didn't hear the end of what you said. Could you repeat your last statement, your last sentence, please?
I just saying I came in personally and relinquished my licenses and closed down with the county, and I don't have anything to do with that. They can already have a lease for it.
Okay, thank you.
Mr. Dick, are you contesting the facts of this case or no?
Well, I not really contesting it because I already went through a lot of these things with the massage board. They did a hearing for my massage license and had similar stuff. The only thing that I see on there is that this soliciting, when I went through that, I came to the state board for cosmetology in person and for the soliciting, and as far as I knew, they dropped the case, so I didn't know anything else about it. And then the board said, we're not going to take any action for you. I gave the paperwork. And then I went through the massage part of it and relinquished my licenses and closed down the business. Like I will admit that I'm not the operator because I'm not a cosmetologist. I'm not a massage therapist, but I've had designated managers and I closed down a business and I have nothing to do with it.
Mr. Dick, can you're not I think you said operator, was that correct?
Well, that's because that's what you guys called it, that owner operator. I'm the owner, but I filed paperwork as a manager, designated manager, run it. Because I don't actually have a cosmetology license personally or massage license personally. I'm a biochemist. I have nothing. I don't know anything about cosmetology.
Okay. So at this time, are you admitting to all of the facts and the violations of law contained into the complaint? Because if you are, then I can proceed with the default.
Okay. Well, I just got it last week because it got sent to my old address and they got a hold of me and I picked it up. So I read through it very quickly. It looks very similar to what they went through with the massage board. And I don't really have contest other than maybe the implications of some of the evidence, because a lot of it I don't really have anything to do with. But like I said, the most important part is the solicitation one. And I thought that case was dropped, so I didn't pursue it. And the police told me that the case was dropped.
Mr. Dick, this is Senior DAG Todd Weiss. What Mr. Sunio is asking you is before we proceed to a hearing to establish the facts and law in this case, if you are not contesting those, then we can stipulate to that on the record and move straight to the disciplinary finding, which it sounds like that's what you're arguing, is that you think the discipline should be reduced or not at all because of different issues, and we can address those. But in order to save the board time, if you're not contesting the facts and law that are in the complaint in this issue, then we can, we don't need to make a factual finding of all that on the record. So are you,
Yes, I'm not trying to argue facts and stuff like that. I just want to be done with this.
okay, so you're stipulating to the findings of fact and conclusions of law in the complaint?
Yeah, I don't see any problem with that. I mean, I don't know what a lawyer would say, but I don't have any problem with that before.
Okay, but you've read the document though. You've seen the complaint. You know what's in it, correct? I just want to make sure you're doing this under, knowledge.
I'll just, from what I understand, the complaint is there was a solicitation, which that happened there. That's what they're saying. That I'm saying my personal experience was the police told me they could drop the case. Other than that, the fines and everything else, I did my best to fix them.
Ms. Dickey, can you go back and restate what you just said a minute ago? The court reporter is having a hard time hearing you.
Okay. The January 31st incident, which says it's solicitation. I only go by what the police said. They gave me the incident report and then dropped the case. So I had nothing beyond that. If the case was dropped, I don't know if it happened or not. My employee didn't work there anymore after that, but I moved on. The other things were the fines. I mean, that's the interpretation of the inspectors, and I paid all the fines and tried to do my best to fix all the problems that they would find me. So that's my stance. I don't have any problem with it.
Okay, let me ask, do you have the complaint in front of you right now, Mr. Dick?
Yes, right here.
Okay, do you want to take one quick look again at the facts and causes of action in this matter to make sure? I just want to make sure 100% you're on board with stipulating to those findings before we move forward to the discipline.
I guess I'm wondering what stipulating to the findings.
That means you're accepting them as true. You're not here to contest those, and then I guess you're here to make a argument as to discipline, if that's what I'm hearing correctly.
Okay, I can do it. That's fine.
Okay, and you're familiar with everything. All right, then. In that case, Madam Chair, I would let Mr. Estunio make his argument for discipline, and then we'll hear from Mr. Dick, and then the board can deliberate on discipline.
Okay.
John, personal service into the record as an exhibit. Okay. Good morning. This case, Joseph Estunio for the record, sorry. This is a case involving the Nevada State Board of Cosmetology versus Q Day Spa. No, sorry. Valley Spa, license number S708692. Adam Spencer Dick, license number NV 202-327-07574. Owner, operator. The division personally served its complaint and notice of hearing on February 5th, 2026. The respondent declined to file an answer, but is here today present and has agreed to stipulated facts and violations of law. At this time, the state will proceed with a default pursuant to NRS 644A. The state calls division staff Janie Huggins. Okay, you're gonna have to swear her in.
Ms. Huggins, can you raise your right hand? Oh. Do you solemnly swear the testimony you will give today will be the truth and nothing but the truth? Thank you.
Good morning, Ms. Huggins. Will you please state your name and current job position? Do your job duties include filing complaints for the division? Do your job duties include mailing and ordering personal service of the complaint and notice documents to respondents? In this case, did you file the complaint, the notice of hearing, and the notice of documents, including the division's exhibits? And did you send all these filed documents, certified mail, and order personal service upon the respondent's last known address? Could you please state those addresses for the record?
One address is 5645 South Eastern Avenue, Suite 7, Las Vegas, Nevada, 89119. The other address is it's the home address in Henderson.
Can you read it for the record? Sorry. If you have it. If you don't.
I
okay.
do.
Sorry. Oh, it's going to be redacted.
It's
Okay.
redacted for the record.
And you have proof of service and the status of documents mailed via certified mail, correct?
Yes.
Can you please explain the status of the proof of service?
For the proof of service, there was one copy left at the business signed for by an employee person in charge, and the other at the address, the private residence, was signed for as received and left with an individual.
I just like to differentiate. First, the division moves the board to admit its exhibits included in the complaint as exhibits 1 through 6.
So moved.
The division now moves to admit the proof of service as division staff has testified to as exhibit 7.
So moved.
The division requests the board move to find the state has proved sufficient service of notice to the respondent, Bowie Spa, license number 70S708692. Adam Spencer Dick, license number NV20232707574, owner operator.
That requires a motion and vote by the full board.
Can I call for a motion, please?
Well, what do we say after we make the motion? Submit all evidence into. What do they want us to say?
Council, you wanted to make a finding that service was proper? Is that what we're?
Yeah.
So the motion can be that
She could say so moved.
so moved works. Let's go with that.
I'm going to say so moved, and I will ask for a second after. So moved.
Board Member Harris, I second that motion.
All in favor?
Aye.
Aye. Any opposed? Motion carries.
Thank you, Madam Chair. The division respectfully requests that as the complaint has already been filed and is part of the record, the board accept the factual allegations and violations of law contained therein as true.
So moved. Oh, and a second, please.
Board Member Harris, I second that motion.
All in favor?
Aye.
Aye. Any opposed? Motion carries.
Given that the respondent has appeared today and agreed to this, and we appreciate your cooperation, Mr. Dick. The board needs to adopt punishment as outlined in the complaint. This includes administrative penalties under 644A NRS and NAC for each violation. The max is $2,000 for each violation. And we're also recommending revocation of the respondent's license for 10 years and full recovery of investigative costs and attorney's fees. Such fines and fees would be due within 90 days of the board's signed order. So no, go ahead. So at this time, what I'm asking the board to do is to adopt administrative penalties, 10-year revocation minimum. That's my recommendation, and full recovery of costs, board investigative costs and attorney's fees.
Board member, well, my question is, what is the total of all the fees?
Can you be more specific?
So $2,000, sorry, my screen is.
So
little-
2,000 is the
Per violation, correct?
2,000 is the max
Oh, okay, total,
per violation.
per violation, oh, okay. Sorry.
Yeah. Do you want to know what that would come out to for
Yeah.
all of them?
Yes,
It would
please.
be 14,000.
Okay, thank you very much.
Board Member O'Brien, that 14,000 is just for the violations, not including the board fees and administrative fees.
That does not count investigative costs or attorney's fees. Those will be calculated at a later time. You
Thank you.
could set a max, like not to go over, but I would defer to the executive director.
Yes, Madam President, board members, Steve McDonald for the record. We can defer that for now because everything that we put into the order will be substantiated and has backup.
Yeah.
You know that I will.
Yeah.
I'm a lawyer as well. So thank you.
Thank you. Board Member O'Brien, I agree. I don't think we need to put a max or stipulation on that. I think we have full trust in our board staff to document all of their fees properly, and we can leave it in their hands to make that an appropriate number
Yep.
that reflects their actual fees that they came out with. Okay. So at this time, we do need to.
Madam Chair, before there's a deliberation and motion, I would let Mr. Dick be heard on discipline.
Okay. Mr. Dick, would you like to respond to what you just heard regarding the discipline?
Yeah, it's for one, I don't have any money. That would be the first. But I've already paid all the fines as they came in and tried to fix them. There's no delinquent fine from anything. I was not told of any other incidents that were coming up. Like I said, I don't actually own the business. It's gone. There's nothing there. I perfectly agree with revocation of the license. I didn't know I don't have one anymore. But as for fines and fees and attorney stuff like that, like if I would have known that this was going to be something this, I guess, magnanimous, I probably would have, fought it to the extent of getting attorneys and whatnot. Because I'm basically saying I just want to be done with cosmetology and massage therapy and all that stuff. I have no plans of ever making another business like that or being involved with it. I was over my head. I didn't know how to run a business. And that's exactly what the massage hearing said too, that I didn't understand what was going on. I trusted people to run the business for me. It wasn't working, shut it down. And that's my plea for you to be lenient because I really don't want anything to do with this stuff anymore. I understand that you guys went through this effort. I wish there was something that would have said like, hey, does he even have a license anymore? Or, like, is the business open anymore? I have nothing to do with it. This license was already surrendered probably 5 months ago, 6 months ago. I can't even think of the time because I just washed my hands away from it and moved on. And nothing to do with whoever's there now. I don't even know if there's a new owner. Don't really care. I don't want anything to do. It was a situation that came up because of my ex-wife. She wanted a spa during COVID, and we got divorced because of COVID, and I was stuck with a lease, and it went downhill for that. So, I mean, if you want, you can go through the whole hearing that I already had for 5.5 hours with my massage board. I just don't want anything to do. I would hope that you guys can see that I have nothing to do with all that stuff. And I wasn't operating a place. I wasn't there. I was a graduate student and a full-time job elsewhere. And it's over. I got rid of it as soon as they told me things were bad, and I paid all the fines and moved on.
Thank you.
I guess that's the most I can say.
Thank you. Do you have a question? Yeah, go ahead.
This is Board Member Detry for board staff. Could you explain what he has already paid and what those were for and the violations?
Well, some of them are in the complaint. I saw some copies of them there.
Member O'Brien, Mr. Dick, I'm so sorry for the confusion. We were asking board staff.
Oh,
So we're going to direct that question to board staff. Yeah, you're good. No worries. Just hold tight.
This is Janie Huggins for the record. The respondent spa was issued several violations during the course of various inspections, and he has paid them. I can go into what the violations were line by line. Stemming from the January 31st, 30th, 2025 inspection, there were a total of $2,100 in citations. They were a combination of sanitation concerns that were found inside the establishment during an inspection, as well as concerns for the separation of space, meaning aesthetics rooms and massage rooms being commingled, which is against our regulations. And there was an unlicensed individual found inside the establishment. I believe she was pending a threatening registration at the time. So there was a citation issued for her being inside the establishment on that day. The business was issued violations in May of 2025 after an inspection, totaling $300. Again, for structural issues inside the business, some issues with the massage and the aesthetics areas not being kept separate, and then some sanitation concerns. And those are all of the violations that had been issued to the business, and they've been paid as of today.
Board Member Wool, has there been, in any previous ownership, or has there ever been soliciting here at this location before, or no?
For this particular business, this was the first business that we licensed at that address. So this was the only issue, I believe, with a solicitation for this particular business.
And then is anybody running this business at this time, or no?
As far as we're aware, Mr. Dick owns and runs the business. It's still operational, and we have not received a license surrender request for this business from Mr. Dick.
So is any of the licenses that he's stating relinquished per a public record for the state of Nevada?
For this business, no, Mr. Dick has not voluntarily surrendered the business license for this. He held another establishment license, which he did surrender.
So per Secretary of State, this business is still operational.
I'm confused on that. Because as far as I know, they took all the licenses from me, from county, and I came in there in person with the licenses and handed them over the counter. So I'm not sure where the mistake is on my part for that, but I definitely don't.
Thank you, Mr. Dick. I'm just checking for public record if this is still showing that you relinquished your license or if it's still public. So that's what I'm asking them. So just hang tight, please.
The Nevada Secretary of State business ID for this business is still active. As I said, he owned 2 establishments. He held 2 different licenses with us. One of those he has surrendered since.
What was the one that he surrendered?
It was called Kaya Spa.
Okay, so not.
No, we do not have a surrender form completed for this business.
Okay. So that's why we have to relinquish license. Okay, thank you. Okay, board member, well, so I'm just confused. So maybe is Mr. Dick confused about what licenses he revocated or what's?
This is Janie Huggins for the record. That's very possible. I am aware that the Clark County license for Bali Spa had been revoked. There was a voluntary surrender of another establishment license that he held. So there are lots of licenses in play. However, this one has not been surrendered. It remains open. The business is still open as we had service from an employee named Coco at the business for this complaint.
Okay, all right, thank you.
This is Board Member Harris. So you just said, for the record, that this business is still open?
This is Janie Huggins for the record. Yes, we believe it's still open.
And someone had a service by the name of Coco, did a service, performed a service?
The service documents for the complaint were served on the business. An employee named Coco.
Oh.
It was left with them. Whether or not they were engaging in a cosmetology service, I don't know.
So, Mr. Dick, do you understand that? Because we're just trying to get an understanding of what's actually going on so you can have a fair.
Yeah,
fair-
I don't honestly know who Coco is. I don't even know what day she's talking about. That they,
Or it seems to me, do you understand your business is still open?
well, I understand that now. That's why,
Oh.
that's why I got this hearing notice, because I thought I closed it and I thought it was all transferred over to whoever bought it. Like, I don't know who bought it or if it's even open up. The lease has been gone. I didn't renew any licenses. I didn't get any notices for renewing any licenses. And like I said, I thought I relinquished everything to Clark County and brought it into the state board.
Okay, thank you.
Board
This
member,
is board member,
go ahead, Anita. Go ahead.
this is board member Douglas. This is to staff. Is it still under the same name or did they change the name at that location?
This is Janie Huggins for the record. I believe it still goes by the same name.
Okay, so Mr. Dick, are you aware of that? Once you close a business, you have to shut everything down and it shouldn't be under the same name. Are you aware of that?
No, this is the first business I've ever had. I mean, I've always worked for a living from at Bellagio and UNLV and stuff like that. So I've never had a business before. I was not
Okay,
aware.
so when you said you sold it, when you sold it and the lease was expired, you gave them back the keys and everything and
Yes,
gave out?
yes. I don't have any keys. I don't have anything to do with it. The landlord sent me I forget what piece of paper it was, but basically saying that the lease is over, terminated, done, and somebody else was going to be renting it.
Okay, thank you.
It was all, as far as I know, it was closed, because during all that time I had asked for probation so that I could finish the last 3 months of the lease. And I was denied that, so I asked the landlord to be let out and that's it.
You might want to check back with them because if they're still using your name, that's kind of like a fraud.
They're using my name or they're using Valley Spa? I'm confused with.
Well, Valley Spa, is that your name? Is that how you opened up the business?
Yes.
Okay, so that's your name that you registered with. So you
Oh.
might want to,
Okay, so I have to go there and tell them to change their name because it's associated with my name.
that is correct.
Oh, I did not know that, sorry.
Board member Wold,
Unless-
oh, sorry, Anita.
Go ahead.
So I did, the business is active on Google. I did text the number that said to text. They did respond. Bally Spa does say it's operational online. Also in the reviews, it said that the business used to be named Kaya Spa, then changed to Bally. So I would just seek professional advisement on how to move forward with with your business. But for the matter, for the record, for us today, your business is still operational. Nothing has been relinquished. So just
No
for the record.
problem. I will definitely go find somebody to figure out how to get this all off my name because it shouldn't be. I was not aware of that.
Okay.
This is Board Member Detry, for board staff. How long did, Mr. Dick own this business? When did he start with, carrying the license?
The initial list, excuse me, the initial license for this business was issued May 11th, 2023.
Okay, thank you.
Board Member O'Brien, when was Kaya Spa surrendered?
This is Lauren Gossage for the record. Kaya Spa was effective closure date was September 1st of 2025. And that was for 3380 East Russell Road, Suite 102.
Is that the same location?
And Board Member Wold, my question for board staff, when a business gives up their license, what is the process for that if they were to come in and voluntary surrender?
This is Janie Huggins for the record. There's a form they would fill out and they would submit a copy of their government issued ID and then we would close out the business.
And about how long does it take to close the business?
Just as long as it takes to either email or provide the form.
So we would have documentation once that's completed.
Correct.
Thank you.
This is Board Member Jeffers. I have a question for board staff. So I just want to make sure I'm understanding this correctly. He had two separate business locations, two separate establishment licenses.
This is Janie Huggins for the record. That is correct.
Okay, and then Mr. Dick, you had mentioned that you've never owned a business before, that you only had one business. So I guess
I can explain that if you want.
okay, yes.
So, I did not understand the complexity of the rules for massage versus cosmetology and putting the two together. So Valley Spa is very small. It was like 3 rooms or something like that. We were cosmetology at first, no problems, nothing, as far as I know, everything was running fine. When we got the massage license, everything got messed up. All the rooms I didn't understand what it meant to be 25, 75%. I didn't actually realize it was supposed to be square footage and you couldn't there were like invisible barriers. You can't cross that barrier. So I didn't understand that. And Lisa and Lauren from county, they helped me understand the rules and I started, trying to fix them. So in order to comply with everything, I had tried to move to Kaya Spa as Valley Spa. And Lauren from county said, yeah, you can transfer your license over. But when it came all the way through, she said, no, you can't because you have Kaya Spa on there. And I said, yeah, I want to change. I don't want to be Valley Spa. I want a new, bigger place that has 5 rooms so I can do 25, 75% with no issues. No, I'm tired of getting fined. I'm tired of the confusion. I'm tired of trying to tell girls, don't go here, don't do this. And the manager not effectively doing that. So I was going to move from Valley Spa to Kaya Spa. And then they said, you can't. So I applied for new licenses and was completely going to get rid of Valley Spa. But at that time I had to deal with the hearings and all that other stuff. So when they came in and took the licenses, I assumed everything was done. And I took the rest of the licenses I had on the walls and brought them in.
To the county or to?
No, to you
state
guys
board?
at your office.
Oh, okay.
And I signed a piece of paper and she photocopied it and I guess those were only for Kaya Spa, but it doesn't make sense because I had 2 different licenses.
Okay. Board staff, can you what, did that happen?
This is Janie Huggins for the record. There was a license surrender for Kaya Spa where I believe he did come in person to fill out the form, and we closed out that business in that license in our system. We have not received any documentation from Bali Spa from Mr. Dick to close out that business. And some
Okay.
of what I'm saying is conflating Clark County business licensing practices with our practices, and it's separate.
Okay. Okay, thank you. I just wanted to, I was getting confused, so thank you for
I was
explaining.
very confused at the time too, trying to close the businesses. I was like filing different stuff and what do I need to do? And yeah, so
Okay, I have one last question, Mr. Dick. So when you, so now it's under new ownership is what you're saying. Somebody's operating this Bali Spa under
yes, I
new
assume so.
ownership.
Yes.
Did you sell it? Did you leave all your equipment? Like, what happened?
Yes, so Dana, not Dana, Lisa from county that came into Kaya Spa and took all the, surrender license to, and we closed it down. She told me she said, you should just get an agent and get rid of the places. So that was the deal. I sold it, and as far as I knew, I don't know if they took over the lease or what for Bally Spa, but I know Kaya Spa is completely sold. And that was, I mean, for dirt cheap because I just wanted to get out of it.
Okay. So as far as this is concerned, I mean, we're dealing with this disciplinary hearing because of the solicitation and everything happened when you owned the spa, correct, board staff?
Correct.
So even though you don't own it, we still are, this is like, we're still dealing with when you did own it, this happened.
Yes, I understand that's what this complaint is saying, but
Okay.
I had already gone through the hearing for it because I had a hearing prior to this one and prior to the massage board one that I came in person and they said, we're not going to take any action against you. And I turned in the copy that showed that the case was closed at that in person. I was there. And so I was not, I wasn't aware that I was missing stuff.
Okay. Okay.
This is Board
Board
Member
member-
Douglas.
Go ahead.
This is Board Member Douglas. Mr. Dick, when you sold your business, did you sell your name also?
It's, I don't know. I'm not sure how it worked. Cause I did a, bill of sale, but I don't remember, it was never put in like, in writing, like you own my name or anything, cause I just wrote a bill of sale for.
Yeah,
That's
I'm just trying to understand how they still have your name,
well,
Bally
I
Spa.
don't know if maybe they don't understand they're supposed to change the name either. It was done through an agent, so, all I got was an email from the landlord saying, sign this paperwork and you're done. And I was like, okay, thank you.
Okay, thank you.
Board Member O'Brien, I have two things. First, on the topic of the bill of sale and the spa sale, can you clarify because you kind of said two things two different ways. I just want clarification for the record. First, that being, did Bali Spa sell? Because before you said you weren't sure if it sold, but you know that Kaya Spa sold. Can you verify or clarify, I'm sorry, that both spas have been sold?
Well, the agent was dealing with both locations. So as far as I know, they were sold as a package deal. That would probably be the way it worked. I don't know. Or if they were sold separately. All I know is the only document I got was for a bill of sale for Bally Spa. And the landlord sent me documents to sign to close out the lease, and that was it.
Okay, thank you. My second question is in regards to the hearing that you stated that you attended. Can you confirm that was which board that was with? Are you talking about the massage board and your hearing with them? Is that what you're referring to?
I had two hearings. I had one with the state board with you guys. I don't know if there's a different one. I'm not sure. But I came into the Nevada Cosmetology building went back in the office there and sat there, and they went through the ticket, I guess, or the complaint of solicitation. And before I even said anything, they said, we recommend doing nothing. And I said, okay, but do you want the document that says the case is closed? And they said, yes. So I turned it in, and that's it.
Thank you. Got it. Okay.
Then after that, I had the massage board hearing there, which is much similar to what this is.
Thank you for clarifying.
This is Board Member Harris. So I just want, just for the record, it's confusing. So he says he doesn't know, he does know. I think he does know about the solicitation of prostitution. I think I'm gonna say he does, right? Okay. So he got rid of one business. He think he does, he think he doesn't. But what we're here today is we're gonna help him out and close his business for the next 10 years. Okay, and then he's gonna be charged some fines in the midst of that. Okay, I just want to get an understanding.
Yeah.
Okay,
Yeah.
thank you.
Right. Yes,
Yeah, we do.
Yep.
I think I'm ready to
Okay.
deliver.
Board, are we understanding what the violations were and the fines that were imposed thereof?
Yeah.
Yes. Okay.
Yes.
Do we have any further questions, concerns, comments for
N-
board staff or for Mr. Dick?
No, Board Member Wold, all I want to say is ignorance of the law does not justify you being exempt from the law. And so I would just highly encourage anyone getting into business to ask for help, get consulted with an attorney, because sitting here saying you don't know when you run a business in a city and you have a lot of compliance is just not acceptable. Especially when there was multiple corrective actions at this location, and there was obviously red flags going off of commingling spaces. So that's all I want to say, because I don't think you don't know this much, but that's just me. I'm just saying a comment, Mr. Dick. So thank you. And I'm ready to deliberate whenever you're ready.
I would agree with you that ignorance is not a defense, but I did every effort I could as I got each thing to try and learn why I was misunderstanding and fixing the issues.
Thank you, Mr. Dick. Okay.
Mm-hmm.
So,
Okay, at this time, are we ready to move forward?
yeah.
Yes.
Yeah. All right. So I call for a motion to,
Correct. So right now we're looking for a motion on discipline.
I'm fine with all the discipline.
for the motion, would you like the 10 years revocation of the license as well as in full recovery of board fees and the 14,000 in fines to be listed, or would we say so moved?
No, I would, he was kind of just telling you what your options are. So I would make a separate motion for all aspects of the discipline that you want to impose.
Okay, so then board staff, before we make this motion, we do need to just discuss and talk about, are we okay or have any questions with the total for the fines? The max is $2,000 per violation. Do we have any questions with that? What about the 10 years revocation of the business license? Okay. And the board, we already discussed the administrative fees, so everything okay. For my board members online, any input on that? Are we good for a motion to go forward?
I'm good with you guys.
I'm good.
Okay. All right, then I'd like to call for a motion, please. Huh?
Okay.
No, we can lump it together, so we can call for the motion with all three stipulations in there.
I, Board Member Wold, would like to make a motion to uphold petitioner Adam Dick C-2025-0311 of fines totaling $14,000 pending attorney fees for the Nevada State Board, a 10-year revocation of license, and what was the last one? What was the last?
That's it.
I forgot the last one.
This is Senior DAG Todd Weiss. Can we amend that to say repayment of the full amount of attorney's fees and investigation costs, amount to be determined, and also add in a time frame for payment of the fines and fees?
And Valley Spa,
Okay,
the Valley Spa part. Yeah.
okay, let's start over. Okay, board member Wold would like to make a motion to uphold petitioner C-2025-0311 Valley Spa on the pending fees per the board and license fees. Allow a time frame to be listed for repayment and a 10-year revocation of fines. Sorry, it's so
You're fine. You're fine.
Okay,
Clarify that it needs to have the 14,000.
of the $14,000 pending license fees
And full recovery of board staff administrative fees.
and full recovery of board administrative fees
And attorney.
and attorney fees. Okay.
Yeah, we have to have an actual time frame for the repayment. It's and completely up to you. It could be 90 days, 6 months, 1 year, pretty much anything you see fit.
6 months time frame.
No, that works for me.
All right, can I have a second, please?
Board Member
This
Detra,
board member, oh, go ahead.
Board Member Detri, I second the motion.
All in favor?
Aye.
Any opposed? All right, motion carried. All right, Mr. Dick, we did make the motion. We are going to uphold the fines and the revocation of the business license. Board staff will reach out to you with more details on how to proceed forward, okay?
Okay, well, what happens if I can't pay it?
I think that board staff will discuss that with you and go forward with you with regards to that question.
And is there an appeal?
Mr. Dick, I would reach out to an attorney and he can go over your like what you can do, what like appeal rights and whatnot.
Okay.
Thank you.
Thank you for your time. At this time, we're going to call for a quick 5-minute break. So the time is 9:59. We will be back at 9:10 or 10:10. I'm sorry, 10:05. Sorry, 10:05.
That means I'm done.
Yes, sir.
Okay, thank you. I do have a pen.
All right, good morning, everyone, and welcome back to the Nevada State Board of Cosmetology. Yes. Oh, sorry. Sorry. You give me a nod when you're ready. Okay, cool. All right, good morning, everyone. And now welcome back to Nevada State Board of Cosmetology's board meeting on February 23rd, 2026. The time is 10:07. Welcome back. I know, right? All right, so at this time, we are going to call agenda item 4B. We're going to our public hearing on complaint number C-2025-0821 for discussion and possible action. The board will conduct a disciplinary hearing regarding the allegations in the complaint filed on January 29th, 2026 against respondent Q Day Spa license number S-708751, business ID number NV 202327689447. Paul Park, owner operator. Upon conclusion of the hearing, possible action includes the imposition of discipline. Yes, of course. Where do you want me to go back? Yes, of course. Possible action includes the imposition of discipline. All right, we have appearances of Joseph P. Estinio, Esquire, Deputy Attorney General for the board, Todd M. Weiss, Esquire, Senior Deputy Attorney General, Counsel to the board. Do we have a member or representative for Q Day Spa present?
Yes, ma'am. Andrew Pastrick, Nevada Bar, State Bar number 9146.
Thank you. Can you speak into the mic?
Sir.
Thank you. Will you repeat that?
Yes, ma'am. Andrew Pastwick, Nevada State Bar 9146, representing the respondents.
Thank you.
Pastor?
Pastwick, Pastwick.
Oh, Pascu. Like that? Okay.
Great. Thank you.
Oh. Oh, I'm up. Good morning, Madam Chair and members of the board. Thank you for the opportunity to speak today. I was having kind of a conversation with counsel and I felt like we should get it on record. Are you not, are you not opposing a default today?
We're not contesting the default.
You're not going to contest the default. Okay. Is there anything you're requesting before I begin?
No.
Okay. Give me a minute. I gotta. Good morning again, Madam Chair, members of the board. This case is involving the Nevada State Board of Cosmetology versus Q Day Spa, license number S708751, Adam H. Park, license number NV 202-327-68947, owner operator. The division personally served its complaint and notice of hearing on February 6, 2026. The respondent declined to file an answer, but he is represented by counsel who is present today, and he has indicated on the record that he is not opposing a default. At this time, the state will proceed with the default pursuant to NRS 644A. The state calls Chief Compliance Officer Janie Huggins to testify. You can stay there. Janie, I'd like to remind you that you're still under oath.
Thank you.
Will you please state your name and current job position again for the record?
Janie Huggins, Chief Compliance Officer for the Nevada State Board of Cosmetology.
Good morning, Janie. Do your job duties include filing complaints to the division?
Yes.
Do they include mailing and ordering personal service for the complaint and notice documents to respondents?
Yes.
In this case, did you file the complaint, the notice of hearing, and the notice of documents, including the division's exhibits?
Yes.
Including the division's exhibits?
Yes.
And did you send all these documents, certified mail, and order personal service upon the respondent's last known addresses?
Yes.
Can you please state those addresses for the record?
One address is the business address, which is 4170 South Decatur Boulevard, Las Vegas, Nevada 89130. And the other address is 118 North Hobart Boulevard, Los Angeles, California, 90004.
Can you explain the status of the proof of service?
An employee of the business received the document, the complaint notice of hearing on February 6th, and the other that was sent certified mail was delivered on February 9th, 2026.
Right. And you have copies of the proof of service and the status of documents mailed via certified mail?
Yes.
At this time, the division would move the board to exhibit it I'm sorry. At this time, the division moves the board to admit its exhibits included in the complaint as exhibits 1 through 8.
So moved.
The division now moves to admit the proof of service as division staff has testified to as exhibit 9.
So moved.
The division now requests the board move to find the state has proved sufficient service of notice to the respondent, Q Day Spa, license number S708751, Adam H. Park, license number NV 202-327-68947, owner, operator in this case.
Right, you need a motion.
Okay. I'd like to make a motion and a vote at this time. So moved. Can I have a second?
This is Board Member
Board
Harris.
Member Douglas, second that motion.
All in favor?
Aye.
Aye. All in favor? I'm sorry, any opposed? Okay, motion carries.
The division respectfully requests, as the complaint has already been filed and is part of the record, the board accept the factual allegations and violations of law contained therein as true.
So move with the motion.
Council, let me just make sure there's no objection to that.
No objection.
I'd like to make a motion. So moved. Can I have a second?
This is Board Member Harris. I would like to second that motion.
All in favor?
Aye.
Any opposed? Motion carries.
Good morning, Madam Chair. Thank you again for letting me speak today. So at this time, I'd like to move to administrative penalties under 644A, NRS, and NAC. Each violation, the maximum fine would be $2,000, as previously stated. Off the top of my head, I do not remember how many violations there were, but I know the total would be 22,000 if the max was agreed to. We are asking for revocation of the respondent's license for 10 years and full recovery of investigative costs and attorney's fees. Such fines and fees we're requesting be due within 90 days of the board signed order.
Council, do you wish to be heard on discipline before the board deliberates?
Yeah, I would request mercy on the board for my guy. $22,000 is a lot of money. He made some mistakes, let's just say that. But I don't think $22,000 in fines is warranted. We agree with the revocation of the license, but we think the fines should be minimalized.
Okay.
Counsel, after conferring with my client, can you elaborate more on why you're asking for lower fees? I mean, I do appreciate your cooperation today for the stipulation, but I would like a little bit more on the record as to what warrants the lower administrative fines, because I believe I think this one was a brothel, and I think there was 2 times Metro went out. Yeah.
Yeah, I don't have much more to add. Yeah.
Shoot your shot.
Thank you, counsel. I'm going to turn this over to the board.
Thank you. Board Member O'Brien, board members, do we have any questions, comments?
Board Member Wood, I have been a part of cosmetology since 2018. I've been a licensed professional makeup artist since 2016 in a different state. And it's really important to me that we uphold a really high standard of integrity and ethicals and morale. And when people come to our industry, I would like for them to uphold it with a very high regard. Especially due to, sanitation practices and that this is not just a hobby. So for me, I am okay with upholding the fees just because this is not an industry you can use to mask a undercover business, especially a brothel. So, but that's just me.
This is Board Member Douglas. I agree with her.
This is Board Member Harris. Yes, I too agree with the fines. So maybe we can, instead of the 90-day, give you a little bit more time to get those fines in.
Yeah.
So maybe 6 months to a year,
I would say 120 days.
120 days.
Yeah.
So, thanks, you.
It is the division's position that it should be 90 days.
Okay.
The provision, so, okay.
That is our request.
Okay. 90 days.
Okay.
Motion.
Do we make a motion?
All right.
Ready?
Yeah. I, Board Member Wold, would like to make a motion to uphold C-2025-0821 Q Day Spa for the $22,000 in fees, a $10,000 revocation of the license, 10-year revocation of the license, full recovery of costs and attorney's fees due in 90 days.
This is Board Member Harris.
Wait. I'm so sorry.
We
We'll have to reword that.
Just one correction. You said $22,000 in fees. That's actually the administrative fine amount.
Oh, that's the administrative fine?
Yeah, you don't need to reread the entire motion. You can just make that. change
Okay.
and-
$22,000.
I'm so sorry, Board Member Wold. It's my, I have a question before
Sorry.
we reword this. The $22,000, that is for the 11 violations, correct? So that would not be the
Yeah.
attorney fees and
Yeah,
the
it's
admin
11.
fees.
It's 11
That's
count.
right. That's separate from the attorney's
Yeah,
fees.
so
and
we need to
investigation
word it.
costs.
$22,000 for violation fees,
Okay.
right?
Or administrative fines.
Administrative
Yeah.
fines. Okay, all right. Are you clear?
So
For your verse.
$22,000 administration fine,
Administrative.
administrative fine, and full recovery of attorney and investigation fees.
Administrative fees.
No, that's investigation.
You're right.
Investigation
Sorry.
fees, attorney's fees.
Okay, you got it, dude. You got it.
Okay. I, Board Member Wold, would like to uphold petitioner C-2025-0821 Q Day Spa and for them to pay $22,000 in administrative fees, a full recovery of attorney fees and investigation fees, a 10-year revocation of the license due in 90 days.
Can I get a second?
This is
What-
Board Member.
We said fine, fees again for the administrative. It's administrative fines. Sorry, I know it's
Administrative fine.
nitpicky, but we gotta be clear on the record. So we can just add that correction and then everything else is good.
Okay, $22,000 administrative fine.
Beautiful. Thank you.
Perfect. Now can I have a second, please?
This is Board Member Harris. I second that motion.
All in favor?
Aye.
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 Any opposed? All right, motion carries.
Thank you.
Thank you.
Thank you.
Thank you, council. I appreciate it.
All right, guys, 1 second. All right, moving forward with agenda item 4C, public hearing on complaint number C-2026-0018 for discussion and possible action. The board will conduct a disciplinary hearing regarding the allegations in the complaint filed on January 29th, 2026 against respondent Cosmetology Institute of Las Vegas, license number SC-14500, business ID number NV 201412567998, Denise Dixon, owner operator. Upon conclusion of the hearing, Possible action includes the imposition of discipline. Appearances, Joseph P. Ostinio, Esquire, Deputy Attorney General for the Board. Todd M. Weiss, Esquire, Senior Deputy Attorney General, Counsel to the Board. Good morning.
Good morning.
Good morning.
Are either of you attorneys?
I am, yes.
Okay. Can we get you to state your name for the record?
Yes.
Thank
Good
you.
morning. My name is Attorney Elizabeth Brennan, bar number 7286. My address, I provided all that information for the court reporter. I represent the respondent here, the Cosmetology Institute of Las Vegas, and Denise Dixon is present here on behalf of the school. And I want everybody to know we take this seriously, and we do contest what's going on here. I talked to the attorney.
I'm so sorry.
Oh.
1 second. Can we just get her sworn in and
Yes.
then we'll go forward with the
Yes.
next part? Denise Dixon, can you raise your right hand? Thank you. We'll get you sworn in.
Ms. Dixon, do you swear the testimony you're going to give today is the truth and nothing but the truth?
Yes.
Thank you.
Thank you. Okay. Kick it over to you, right?
Okay.
Yeah.
Well, I'd prefer her to finish.
Yeah, go ahead.
Well, I just, as a matter of housekeeping, I was speaking with the Attorney General's office representative before we started, and he and I both agree that this hearing is a contested hearing, and he and I both believe it's going to take 2 days. And so I guess the question is, or could possibly take 2 days, but the question is, do we want to start now and reconvene? That's what he and I were talking about, whether we want to start and do it in 2 separate parts, or whether we should do it all in 2 days in a row.
Yeah.
Or 2 full days, I guess.
But the
What-
question, I think what she's trying to ask is, if it goes past today, when would we come back? And that's hard to answer.
Yes, it is.
Do you want to?
Stephen McDonald for the record, Madam President.
please.
I apologize. Yes, we can't tell when we will reconvene, obviously, because it has to be agendized and follow open meeting law. So we can go ahead and start today, Madam President.
Yes, please.
And then if we get to wherever you believe and the board feels that we can stop between the 2 attorneys, then we reconvene and get another date as soon as possible. Thank you.
Thank you.
Okay.
Is it my turn?
Your turn.
So I guess a couple housekeeping things. Are there any exhibits that you're willing to stipulate to that were included in the complaint?
I
I know
do,
it's I know it's weird because they were included in the complaint, so they're almost our public records now.
right. We contest the facts and the application of law as stated in the complaint.
Okay.
So, I understand the rules are a little more liberal in these administrative hearings. So I mean, I'm not concerned. I'm quite confident that the board is going to be looking at and reviewing the exhibits. So I don't necessarily object to the exhibits being introduced and accepted into the hearing record, because like you said, they're attached to the complaint, but I don't accept what that means in the implications of everything. And we're going to have to have testimony from witnesses regarding each of these exhibits. So I don't know if you would prefer to just it might be easier and simpler to just have your witness go through one exhibit and admit it as we go, or is that what your preference?
I mean, that's what I get. Yeah.
Okay, I'm
That's
happy
fine
to
with
do
me.
it that way.
Okay. And then, just so the record, no answer was filed today, and you appear, but you did appear.
Yes, it's my understanding we don't have to file an answer. We can appear and contest things here today, and that's what I'm here to do.
Correct. Thank you. Yeah, I
Yeah.
just wanted to put that on record.
Yes,
Thank you, opposing counsel. Can I proceed with my opening
Yes,
statement?
please.
Thank you, Madam Chair and members of the board, for the opportunity to speak again today. I'm here because the issues in this case aren't just paperwork problems. They affect real students who rely on the school to do things correctly, like register students on time, keeping accurate records, supervising students properly, and maintaining safe and sanitary conditions. The evidence you'll hear today is mainly the board's own record and inspection reports. I'm going to call 2 board witnesses, Bertha, who reviews records for testing eligibility, and Janie Huggins, who handled compliance and inspections. Through them, I will introduce the exhibits and ask simple questions about what the board found. At the end, I'm asking the board to consider how these repeated problems, later missing student records, timekeeping problems, supervision issues, and sanitation and equipment concerns can directly block students from testing, delay licensure, and create financial harm. Thank you.
Thank you. And if you'd like to make your opening statement.
Yes, I would, please. Good morning. Thank you for your time and consideration of this matter. My client takes this case very seriously. She respects the process and the integrity of the cosmetology profession and has strived through the years to maintain that. As we proceed through the evidence in this case, you're going to see that she has been she's been licensed by the board 6 times total. Her initial license was in March of 2015. She's had 5 renewals since that time. What we see in this complaint are things that occurred. Many of the things occurred prior to one of these renewal periods. And my client, the evidence will show she took, if there was a fine, she paid it. If there was correction action, she corrected it. And the board continued to renew her license. And she's respectfully requesting that they continue to renew her license and that they do not revoke it, and that this business means everything to her. And what you will see in this case is that she and her team have, many of whom are here today. Unfortunately, one of them passed away recently, and the funeral is scheduled. And one of these members was like a daughter to her. So this is a very difficult time. But otherwise, that staff member would be here as well. What you're going to hear from our witnesses and from the board staff, I believe, is that they have cooperated and they do understand the importance of the integrity of this profession, and they want to do everything to maintain that, and they will continue to do so. You're going to hear that my client had a misdemeanor. She pled guilty to a misdemeanor back in, I don't know, 8 years or so ago. In August of 2018, it was a misdemeanor. She entered a guilty plea for certain things to avoid what could happen if she went to trial. Many people do that. That was almost 8-something years ago. She's been an upstanding member of this community and very well thought of and very well respected. The board and or the staff and or the Attorney General's office should have or did know about this because it was, as their exhibit, it was published back in 2018. So this shouldn't be new news. So, that was published in 2018. They did a 2nd, 3rd, 4th, 5th renewal. This board did, since this board knew or should have known, and the staff knew or should have known, and the AG's office most definitely knew about. And she has detrimentally relied. I mean, if you were to shut her down now, because somehow this is claimed to be new information, she's detrimentally relied on the fact that everybody can see that she's got good personal integrity and good moral character. She's continued to lease her beautiful building. She's continued to expand her programs to provide wonderful additional offerings in the community as they are become on board, like the advanced aesthetics course. And it's just simply old news. And it should not be a basis for you to revoke her license today. The evidence is going to show that she's earned many awards within the community. You know, she's in North Las Vegas, and she runs a shop in maybe, let's say, one of the lesser privileged neighborhoods in this community, and it's a service that's needed, and it's welcomed. And the evidence is going to show she's trying to cooperate and wants to improve and is improving and will continue to improve, but she needs to continue to be in business. The evidence is going to show, for example, she's so well respected that in 2019, the Urban Chamber of Commerce gave her school the Small Business of the Year. In 2021, the Best of Las Vegas, the Review Journal, all these people in the community that she serves, they voted her Best of Las Vegas. She's the bronze winner. Best trade school, technical school. The evidence is going to show in 2022, the Nevada Business Awards, sponsored by the Nevada State Bank, found the Nevada Business Small but Mighty Cosmetology Institute. They were one of the winners in 2022. So what we have is a lady of integrity, a lady of commitment, a lady of service to this community, and the matters that are in this complaint have been resolved, and she's renewed. And I don't really understand or know what was the impetus to cause this complaint to be filed in January of this year. And it comes as quite a surprise to my client because she's not paid any fine. She's done every corrective action, and she had a training by the staff, which was very helpful and most appreciative in the end of 2025. And she asked for the training. That's what the evidence is going to show. She wants the training. She wants the help, and the staff has been very kind and helpful. But we need to continue in that vein of cooperation and continue with her license and not have these severe death penalty that's on the table here. In pursuance to the guidelines that the executive director kindly assisted in December of 2025, providing the school with some things and plans to put into place, what the evidence is going to show is that she came up with revised, updated, amended standard operating procedures, submitted them to the staff, and it's, it's 49 pages. And this was just done in January, pursuant to the request. So to get this complaint a week or two after we're just moving right along, thinking we're doing everything that we should be doing, we don't understand. And we think it's wrong. Some of the things you're going to hear when you read the complaint, as presented in the complaint, they sound kind of bad. But when you understand, what really happened or whatnot, I got to think some of these, unfortunately happen to a lot of the schools, and people make mistakes. They fix them. A typo happens. A hard name happens. You might have a toilet that's got a problem or something. People fix things. They happen. She's been cooperative and done that. And you've renewed her license. So some of these things you're going to hear that I think one of the issues is a square footage issue. And, as the board knows, at some point in time, the laws were revised to add so that there could be schools just for nail techs, for example. If you didn't want to provide a whole school to do every branch of cosmetology, you could have a school that just did nail tech. So our law was missing, well, what are the hourly what's the square footage requirements for that? So that law was amended to add that. Now, there seems to be some confusion, I believe, maybe in this entire industry, perhaps, as to how to interpret that statute. Because when I go on the cosmetology website and I see your current list of schools, and as I understand the square footage demand that's being put on my client all of a sudden, that would justify her revoking her license because she doesn't have the square footage. If the law is as my client is being purportedly alleged to follow, then you're going to have to shut down a lot of schools, because I'm sure that this board believes in even treatment of all schools, whether they're a big corporate entity or a small minority-owned business, female-owned, Black-owned minority business. It would have to apply around the board. And as I understand, my client has had the same square footage since she opened. And she opened almost 11 years ago. And she's been licensed 6 times by this board. So for us to receive a complaint saying we don't meet the square footage requirements and we got to revoke your license seems a bit confusing. And, as I understand it, cosmetology includes several different branches: hair design, general estheticians, nail tech, advanced esthetician. The good thing is my beautiful client here she wants to improve this industry. She, unlike some other of these schools, has spent the money, made the financial investment in the expensive equipment to put on the advanced aesthetic program. And it is now licensed as part of her program and offered. Now, there are other schools that do that as well. But those are all branches of cosmetology that this board has always believed or had a 5,000 square foot requirement for 25 students. And it has always been interpreted that way, because you would not have continued to relicense her and renew her license. And you would not have continued to license and renew all the other schools that don't have the square footage that you somehow are claiming needs in this case. As I read the complaint, the complaint seems to suggest that if you're going to have, that you've got to add up all those sections such that you've got to have like 14,500 hours, or if you to do hair, general esthetician and nail tech, but if you do advanced esthetician, you got to have 18,000 square feet. I don't know of any school, cosmetology school in this state, that meets any of those square footage requirements. Academy of Hair Design, they're a full cosmetology school. They have like 11,000 square feet. They don't meet that. AM Beauty Institute, they don't meet that. Avalon Institute, they don't meet that, and they provide advanced aesthetics. By the way, Academy of Hair Design, they provide advanced aesthetics. They don't meet that. Avita doesn't meet that. Avalon doesn't meet that square footage requirement. Avita doesn't meet that square footage requirement. Euphoria doesn't meet that square footage. Expertise doesn't meet that square footage. Milan Institute doesn't meet that. Paul Mitchell School doesn't meet that. Sierra Academy. You see what I'm saying here now? This is nonsense. So if there is some confusion about how we interpret that statute, then which I do believe, I think it's confusing, honestly, I do. And I'd be happy if the board would like to file a petition to amend or revise that legislation as provided in NAC 644A.990 so that we can get some clarity to it. And I'd be happy to work with the Attorney General's office to provide clarity for the board. Because I think that the allegation in this complaint stems from a little confusion. And I think that in fairness to the staff, they have started putting that in their investigation reports because they're trying to do their job. It's not their fault. They're trying to do their job and say, maybe we need to evaluate this square footage issue because they're aware of the change in the law that took place, I believe, in 23 or something like that, 23, 24. So that's what the evidence is going to show. And as far as the time issues, what you're going to hear is my client she was actually commended by the board and staff years ago when she first opened because she was one of the first to institute this biometric time clock where you use your finger to log in and out, and that this paper logs for timekeeping is just kind of a backup that she's kind of had just in case something were to happen, she could use that. But the official time is the biometric clock. And so you're going to see that she's just been cooperative. Her staff has been cooperative. And we ask that you deny the complaint in its entirety and let us continue to work together with the staff on a collaborative basis to improve this business. Thank you.
Thank you so much.
Thank you.
At this time, I would like to call my first witness. Thank you, Madam Chair. I'm going to call Janie Huggins, Chief Compliance Officer, to stand. Yeah.
Ms. Huggins, I'm gonna swear you in one more time. I know we did it a couple matters ago, but just to be safe, you please raise your right hand. Do you solemnly swear the testimony you're about to give is the truth and nothing but the truth?
I do.
Thank you.
Good morning, Janie. Can you once again, please say your name and job title for the record?
Janie Huggins, Chief Compliance Officer for the Nevada State Board of Cosmetology.
Janie, how long have you been Chief Compliance Officer?
Since November of 2022.
What are your duties as Chief Compliance Officer?
I oversee the inspection department, as well as establishment licensing, other areas of regulatory compliance where we do investigations on unlicensed activity or other businesses that are not in compliance with our regulations. I also oversee the staff that inspects schools and deals with school records.
So you investigate school compliance issues, correct?
Correct.
Were you involved in audits, inspections, and communications in this case?
Correct.
Please turn to Exhibit 1. Oh. Sorry, we're having technical difficulties.
I'm trying to get my act together over here. So I don't make noise.
Looking here at Exhibit 1, does this show that the school is licensed by the board, correct?
That is correct.
Do you believe that the documents or records included in Exhibit 1 are true and accurate?
Yes,
When a school is licensed, it has to follow the board's rules on supervision, records, and sanitation, correct?
correct.
Madam Chair, I move to admit Exhibit 1.
So moved.
Thank you. Please turn to Exhibit 2.
We have no objection to that exhibit being admitted. Did you want me to object as I go along if I have an objection?
Well, if you didn't,
I don't, I want to follow your procedure, so.
no, if you didn't object, I would just assume that it was admitted. Yeah. Is that correct, board counsel?
Yeah, I mean, it's council, if you have an objection, Madam Chair, before you admit, why don't we just give a second for council so she can just state an objection if she has it.
Okay.
Janie, will you please walk me through Exhibit 2? What are we looking at here?
Exhibit 2 is email correspondence between myself and members of the respondent school discussing an audit that was performed on what we call their school portal, where there were unaccounted for students that had been in the system without either a withdrawal or a completion. They were advised, provided a list of names, and told them to essentially go through, check their records, complete or withdraw any students that needed to be completed.
Do these documents and records included in Exhibit 2 are true and accurate?
Yes.
I move to admit Exhibit 2.
Any objection?
I don't object to their admission, but I'd like to question the witness on it. So I don't know.
I'll give you, no, you'll have a chance when this is going to get complicated because I've got a lot of questions to ask and then you'll be able to cross her once we're done. And then the board will get a chance to also ask her questions.
So I don't have to keep interrupting you. I'd like to make sure I understand the procedure so that I'm not bothering anybody.
Direct them to board counsel.
Okay, so, are you gonna, I mean, I don't object to the exhibits being admitted, but I object to what they mean. So if you're gonna are you gonna come back and question her later on this exhibit, or you're not doing that? Or-
No, I'm not. I mean, I have more questions about the exhibit. I was just, I was kind of laying a little bit of foundation,
Okay.
getting it admitted. Then I had a couple of questions.
I don't object to this.
You did indicate you're not objecting to the admission of all the exhibits. Can we just,
I feel like we need to establish it. I stipulate to the admission of all the
Okay.
exhibits, because I don't want to waste our time arguing about that, but I do want to have testimony on whether it's, just because I stipulate that it's admitted, I'm not stipulating that it's relevant. I feel like some of it's completely irrelevant because she's already paid the fine, done the correct action, and the board's already renewed her license. And no further action should be taken on it, but
you're talking about the, like there are exhibits that refer back to citations. You're referring to those exhibits.
I'm referring to probably almost all of your exhibits I think are irrelevant because you're dealing with things that are either do not justify revoking somebody's license for 10 years, like is being asked here, and there's legitimate explanation for why something happens. I mean, if somebody's name is put in and it's spelled wrong and they put an N when it shouldn't have had an N, I mean, that's why we're going to revoke somebody's license.
Council, that's not relevance. That's the weight of the evidence, which you have.
Be questioning these witnesses and on attacking the exhibits on the weight of the evidence because I don't think they hold much weight. We expect that's.
So
I'm just going to stipulate to the exhibit entry and then I'll question them when it's my turn.
I'm going to move that we admit exhibits 1 through 30.
So moved.
And there's no objection from council.
No objection.
Thank you.
Okay. Sorry.
No, I think it just would be better because I don't want to slow down the process.
Okay. Okay, am I up?
Yeah,
Okay.
so now we can go forward. with
Yeah,
the
I got a
Okay.
couple of questions
Okay.
on exhibit 2. Janie, in simple terms, what was the board asking the school to do with the students listed in that audit?
The board was asking for laws. Students that have completed a program need to be withdrawn or completed within 15 days of their last date attendance. So the unaccounted for students indicated that some students hadn't been withdrawn or completed from a program properly. And we were asking the school to do that.
Other than what you just said, was there anything outside of the ordinary that you found here?
No. Just the students that had not been properly.
Please turn to exhibit 4. Will you please walk me through what we're looking at here?
This is email correspondence between myself, Bertha Jackson, and the former Deputy Director, Adam Higginbotham, where we are discussing some concerns about a student who had reached out to another staff member with issues relating to them submitting their testing application. They had one unique identifier, which we typically use as a social security number in the system, and it differed from the one that they had gotten.
Why do conflicts in applications versus school records matter when someone is trying to test?
When someone is trying to test, if the records don't match with what we have in the system and they don't log of their testing application.
Please turn to exhibit 3. I know I'm going backwards, sorry. Will you walk me through this exhibit? What am I looking at here?
This audit of the student. So,
Sorry, this is Board Member Jeffers. We can't hear.
Madam Chair, can we take 2 minutes?
Yes, please.
I'm gonna go to that.
Yeah.
Walk.
Oh,
Board Member Jeffers, this is Janie for the record. Can you hear better now?
Yes, very clear. Thank you.
Thank you.
You did 3, and then I did 4 before, right?
And that's when she couldn't hear. No, she couldn't hear me.
Oh, so we have to redo. Right. Perfect, we're in order now. Yeah, we're gonna go back.
No, 4. Okay.
No, we're on 3, the letter.
She didn't hear 3, so we're just, she missed 3 and 4.
3. Oh, got it. Sorry. It says 4C. Sorry. I was confused. So this is Janie Huggins for the record.
Sure.
Oh, thank you for joining us again for the Nevada State Board of Cosmetology. The time is 11 a.m. on February 23rd, 2026. Thank you for bearing with us while we had that technical difficulty. We are going to jump back in to Janie Huggins' testimony. So go ahead.
So I was told when we came back on that 3 and 4 were not heard, so we're gonna start over, but I'm gonna go in order this time. We're gonna redo exhibit 3 and 4, and I apologize.
No worries, it's fine.
So this is Janie Huggins for the record. Exhibit 3 is an audit that was done on school portal accounts for the school where they were checking for timely enrollment. At the time, the regulations required that students be enrolled through the portal within 45 days of their start date. This was a report of students that had exceeded that 45-day timeframe and a letter to the school saying they were not in compliance with that particular regulation and that we would be dispatching inspectors.
Was there anything out of the ordinary in the report?
No, at this time, we were just doing audits for enrollments and they had findings that equated to a deficiency where they were only enrolling about 70% of the students in a timely manner.
Please turn to exhibit 4.
Exhibit 4 is some email correspondence between staff, Bertha Jackson, and the former Deputy Director, Adam Higginbotham, with some concerns over inaccurate Social Security numbers used to enroll students in the portal. That student was planning on testing and had concerns that the discrepancies between what was submitted by the school and what they had been received would lead to issues. The correspondence goes back and forth, outlining the issues and the concerns.
Back to on my previous question, why do conflicts in applications versus school record? Okay. Why do conflicts in applications versus school records matter when someone is trying to test?
If the records that we were initially given have discrepancies, it makes the information seem unreliable.
During COVID, did the board approve distance learning?
Yes.
Was it limited?
Yes.
What were those limits?
I believe there was a limitation of no more than 120 hours of distance ed per month.
Later, when graduates applications came in, what didn't make sense to staff about the training timelines?
The time frame for a completion seemed too fast. Essentially, we were getting students that had completed in just under 3 months for 600-hour programs. Usually that program takes just over 3 months.
Thank you. Please turn to exhibit 5. Will you walk me through this, Janie? What am I
Yes.
looking at?
During COVID, after we had received the information from Exhibit 4, we had started to ask this particular school for student records because we cited that they had completed a little quicker than what a normal student would allow. It should have taken them longer due to the constraints from COVID being imposed on the students. So when students would apply for testing, we would request their clock-in records. This is an email chain between me and Denise Dixon requesting student records.
Please turn to, what am I looking at here?
These are the student hours from Milady, which is their online program from COVID.
I'm sorry, what exhibit are you on?
We're on exhibit 5.
And then they're also their clock in and out records from their biometric system as well.
Did any stand out enough to like that you recall with that would like was a red flag?
Yes, at the time, it was a red flag that many of the clock in and out records through the UAttend system were very, they were 8 a.m. to 5 a.m. or very specific times over and over and over again. It didn't appear to be an organic punch where if you were in a line and you were waiting, it was 801, 802, things like that. We also noticed through the Milady records that there were really high hours of completion in the program, in the online hours program. It exceeded what the board was allowing at that time.
When you said 8 a.m. to 5 a.m., did you mean 8 a.m. to 5 a.m. or 8 a.m. to 5 p.m.?
Yeah.
Okay, just making sure. Please turn to exhibit 6. Janie, what are we looking at here?
This is email correspondence between compliance staff and inspectors that had there were concerns about adequate supervision from the instructors. Upon inspection, one of the inspectors found that there were 2 student instructors that were both there but had not passed their test, and therefore their licenses were no longer valid to be used, and no 45 extension letter had been requested for their instructor. They also obtained student records from that inspection that were to be reviewed by the staff.
When staff reviewed time records, what were the problems found with the hours and limits? Did that deal with this exhibit?
Yes. Again, we found that the hours seemed to have exceeded what would have been allowed.
Moving on to exhibit 7. Will you please walk me through what we're looking at here?
Email correspondence between a former student of the school and board staff who had encountered difficulties in testing. The student had been enrolled in program. So when they went to test at our testing vendor, they were not able to test because they were being given a nail technologist examination. The nail tech instead of the examination, which was the program that had been completed by the student.
Was this ever fixed?
Yes, it was fixed after the student had reached out to the get additional documentation to verify what the student had been telling us, and then it was updated given the appropriate exam.
Was there a delay time in that person being able to test?
Yes, it did delay the student.
Do you recall how long?
I don't recall how long. Would imagine just a few business days.
What can you, and you might have already said this, but why does being in the wrong program matter for testing?
It matters for testing because the way the school would enter a student into the portal, it would automatically trigger them down a path to receive that specific exam for that program as well as that specific license type. It also speaks to the accuracy of the records of the school. When they enroll a student or when they provide records to us, they're attesting to the accuracy of the correct program hours, the correct program type, and the accuracy of the record in their entirety.
Please turn to Exhibit 8.
Exhibit 8 is the text of a letter that was sent to the school during when the 75-hour laser course for grandfathering for advanced aesthetics was happening. There were several instances of students that were not licensed and therefore not eligible for grandfathering, so they shouldn't have been taking the course. After we had so many incidences amongst the laser course providers, we began sending out letters letting them know that this was their final warning before we would bring them before the board to stop the program.
So who was allowed to take that training then?
Anyone that would have been eligible for grandfathering, so it would have been a licensed esthetician or a licensed cosmetologist. The issue that we were having were students were taking it while they were waiting to test, while they were waiting to complete their program, and they weren't licensed and they were therefore not eligible for the program, for the laser course.
So is it a program that you take after your license?
Yes, you would only be eligible to take this after you were licensed. You would only have been eligible for grandfathering if you were licensed. And it was one of the requirements and stipulations for providers offering that course to ensure that the folks that took it were licensed properly.
Thank you. Please turn to Exhibit 9. Please walk me through this.
This record is pertaining to another student that had been enrolled into the school portal incorrectly. Their testing application being rejected.
So, so if I'm understanding you correct, this graduate applied for the nail exam, but there was no record of training. There was no record.
Correct. So when a student enrolls, they have at the time they had 45 days to put them into our portal, and when they complete, they have 15 days to provide a completion notice in their final time record. So in some cases, this student was not entered at all. So there was no enrollment, no completion, and it had to be backdated because there was no record of the student in our system.
So just so I understand correctly, so 30 days to enroll, and then it must be completed within 15 days?
No. At the time, the regulation now states it's 30 days, but at the time it was 45. So when a student begins any program at any school, they have by law the school has 45 days to send an enrollment document and pay a $10 fee to the board. If they don't enroll, then they wouldn't be in compliance. If a student graduates or withdraws from the program, by law, the school is to produce the final time record of that student within 15 days of their last date of attendance.
Got it. 15 days for hours. Okay. So for this particular student, did they only enter the time after the problem was found?
Correct.
Okay, moving to exhibit number 10. Will you please walk me through this one?
Yes, this exhibit is email correspondence between myself and Denise, providing her with a citation invoice from an inspection that had occurred a couple of days prior to.
What did the inspectors find in 2023 related to sanitation equipment and possible mold?
The inspectors found an area that they believed to have black mold, as well as issues with the equipment not being used or operable. There were some issues with the dispensary sink and shampoo bowls. There were also some sanitation concerns with the flooring and trash can not having lids, and some other sanitation things just not being kept clean.
Did follow-up did the follow-up show that the mold issue still wasn't fixed?
There were inspections to follow up on the mold issue that showed that it was repaired.
So there's no evidence of any remediation.
No.
Okay. Please turn to exhibit 11.
Is another citation invoice. Came after an inspection that had findings. Additionally, I believe that in this email correspondence, I explained to the owner of the school that we were not issuing as many violations to correspond with the findings because we were aware that the school had been already issued several violations, and we were looking to get them into compliance versus put them further down a financial burden. But I did state that if the violations were to continue, that we would have no choice but to bring the school before the board.
What was found about the required equipment being stored away and not available for the students?
This was, I believe, the second inspection where the advanced aesthetic equipment appeared to be locked in a room or an office. It didn't appear to be used and the students didn't have access to it, which gave us concerns about the students having access to that equipment and being shown the proper curriculum.
Please turn to exhibit 12.
This is an inspection report from the inspection from March 5th of 2024. In this report, there's some concerns about the instructors and having adequate supervision from the instructors. I believe there were only 2 instructors present for the staff. It had been clarified that someone was absent that day. Again, the equipment for the advanced aesthetic program had been locked in a closet, not readily available for the students to use. the mold was still observed on that day. And then there were other issues pertaining to equipment not being kept clean or in good condition.
So the locked equipment concerns and the mold concerns continued into 2024.
Correct.
Please turn to Exhibit 13.
This is another inspection report from the May 2024 inspection. I think the biggest concern that was found from that was that the time clock had been broken and they were relying on paper sign-in and out sheets for that day's attendance. I believe it was also noted that the mold issue had not been addressed properly.
And can you be more specific that so the time clock was broken? Does that like is it how does the time clock operate?
This school, I believe, had a fingerprint scan time clock. We do require all the schools to have some form of a biometric on their timekeeping device to avoid any missed punches for hours and have accurate time records. And time clocks do go down. They're digital, right? It's going to happen. So just noting that they were taking paper records because their biometric system had been down that day.
And just to be clear, I think you said it already, but the mold issue still hadn't improved. I think we're in May now.
Yes. I think that there was as well as equipment not being kept in good repair or kept clean. That had been noticed on previous inspections and not corrected.
Please turn to Exhibit 14. One more question on number 13. Do you recall if they ever reported the mold to OSHA?
Report the mold to OSHA.
And did anything come of that?
OSHA told our staff member that it was essentially not in their jurisdiction. It's not something that they handled.
Thank you. Will you please walk me through number 14?
Exhibit 14 is another example of correspondence regarding a student that was not properly enrolled. Reached out wanting to know how to move forward with a particular student, and it was discovered that she wasn't enrolled within that 5-day time period and was not completed properly.
So what exactly happened when the school called about the graduate?
They were directed to essentially they had to create her record at that time.
Now, I may have already asked you this before, but why is this a serious problem for a student trying to test?
There was no record of this student being a student, and it would appear that there was about a 2-year delay. So she enrolled in 2021, completed in 2022, her in 2024. So it just brings into question the reliability of the records.
So were they out of compliance for 2 years? Is that what I heard?
On this particular student, yes.
And you can't test if you don't have hours and you're not in the system, correct?
Correct.
How long was this student not allowed to test for? Like, how long did it prevent them from being able to get their license?
According to the correspondence from the school, they didn't want to complete her because she owed a balance to the school. we have a feature in our portal where you would still complete the student, but you would lock their account if they were not financially current. So regardless of the financial status of the student, there was a process for all of these things to be addressed. But essentially, until she became financially current and they reached out in 2024, it would have taken probably about a week for all of the documents to be done properly.
So it's my understanding that schools can withhold hours, but they still need to be registered in the system
Correct.
to
So
be in compliance.
correct. There's 3 different regulations at play there. Our laws and regulations will allow the board to assist a school when it relates to either getting financial funding or if they owe a balance, if a student owes a balance. But there are also record or regulations specific to the student records outside of that, that again states they have to be enrolled within a certain time frame, they have to be completed within a certain time frame, and their records have to be kept for that student's training.
So if I had a student and they owed me a couple $1,000s, but they had completed the program, I could prevent them from testing.
By locking their account, yes.
Thank you. Please turn to Exhibit 15.
Exhibit 15 is a report from September of 2024. During this inspection, there were some violations noted. The structure of the school. So there was an issue with an outlet, an exhaust fan, and then some other issues relating to the ceiling and there were some concerns about the instructor being a student and that had to be rectified. Reminder. The record being kept. There's a note at the end that says the sign in backup, meaning the paper logs, should not have end times until the student leaves. If an instructor needs documentation on when students are leaving, it should be on a notepad or post it as it can seem fraudulent if written on the backup. There were several students on the sign-in sheet that were not in the system. The reminder to enroll within 30-day time.
Did I hear you say that there was a student who was teaching a class?
It appears that there was an instructor who was the advanced aesthetic instructor, but she was also enrolled as a cosmetology student. The staff at the time wanted them to ensure the 2 roles were completely separated.
So that wasn't really a violation.
No, it's just an area of concern.
Okay. Did you suspect that they were pre-filling timesheets or logs?
Based on the note, yes, it looked like there might have been pre-filling of the time records.
And this raises concerns about hours being accurate, correct?
That is correct.
Talk to me about the square footage concerns. Why does advanced estheticians have to have this required square footage? Did they have it? Did they not?
Oh, the school was originally licensed under certain programs and it met the square footage requirements. In 2024, in April, I believe of 2024, the laws regarding the square footage changed. So the school was no longer in compliance with all of the requirements for all the programs that it held. Because this law change and they were previously licensed, it was
No, you're good.
just something that the inspection staff wanted to put on the radar for a solution to be found down the road.
Thank you, Janie. Can you please turn to Exhibit 16?
Exhibit 16 is another inspection report that cites various issues with furnishings, some other issues relating to the outlet, the previous inspection not being corrected from the previous. And some more furnishings and things just not kept clean or in good repair. So it cites some warnings in some areas to correct. There is another reminder to enroll the students in the 30-day timeframe. And it speaks more about that square footage requirement.
Did in this did the square footage issue come up again? Were they supposed to submit something?
No, it's just something that I believe was discussed and therefore documented on the report. It's something that the school was not in compliance with, but we needed to find a solution for them, whether it was a variance or other solution.
Please turn to Exhibit 17. Walk me through this one, please. Okay. Wait, 17. Yeah, we're on 17.
Exhibit 17 looks to be a series of student records that had various issues with them that were found from either in entering enrollments or through an audit. Staff identified some issues where they declined, and they said they started is when they were completed.
So, in these records, what kind of student record problems did staff find in early 2025?
These were mostly related to enrolling students properly, either in a timely manner. If there was a letter of credit to be issued, if that was missing from the enrollment or had been properly requested, or the dates seemed off.
Please turn to Exhibit 18.
So Exhibit 18 discusses some more student records that had issues with their enrollment. They had either had issues found through an audit process by our staff. There were missing letters of credit or dates that exceeded the appropriate time frame for enrollment.
Do you remember what deficiencies, such as student enrollments, withdrawals, and other records had issues?
I believe with these records, there were some issues where students had been enrolled after they had either received or requested a letter of credit. And there were others that the issue was that they had not been enrolled within the proper time frame. I think that between our staff and the school staff, they cited a technological issue being the cause of why these students hadn't been enrolled in a timely manner. So our staff had advised them to enroll the students as soon as possible. So because they were already out of compliance with that time frame. And I think that this email chain is checking in on that, where we advised them, go ahead and enroll those students. We will not issue violations relating to the going over the 30-day time frame. And even after that period, that grace period, essentially, they still hadn't been properly enrolled.
Moving to Exhibit 19, please.
Exhibit 19 is from the March 2025 inspection. There were compliance reviews and citations issued from this inspection, and there were concerns about the equipment requirements not being met. And there was also some concerns with the sanitation issues, wax buildup and nail clippings, things like that, other areas of visible debris. There was some equipment concerns where they were directed to adjust their equipment that they have.
Walk me through the citations and corrective warnings. What was observed during this visit?
On this visit, there were several violations observed. One was rust being found on nail implements and tools. Rust being found on a metal implement indicates a failure to properly disinfect tools and implements. According to our laws and regulations and best practices, clean your implements with hot soapy water, remove the debris, then clean with hot soapy water, then soak for a contact time, which is typically 10 minutes, and then remove from the disinfectant and store in a clean, dry area. Rust being on the also some issues with cabinet doors being broken that needed to be repaired. There was a wax buildup on the floor of the aesthetic service rooms, and the floor around the pedicure bowl had nail clippings and other debris. So basic sanitation violations. These areas were not being cleaned and disinfected according to our regulation.
Do you see a lot of sanitation issues at schools?
Typically, no, not this many.
And talk to me about the supervision of the healthcare professional regarding the advanced esthetician program. What was the issue there?
There was concern that the healthcare professional needed to sign off on the new collaboration agreement form, and we would have to do some prompting to get that updated document to ensure that the advanced aesthetic program had that supervision.
Was there an issue with supplies and equipment?
Yes, there was some equipment that they didn't appear to have. So the report essentially corrected the school to let them know that you didn't know you needed this, you do need it. Pay the equipment, make sure that you're in compliance with the requirements.
Please turn to Exhibit 20.
Exhibit 20 is from the 2025 inspection. There were some violations issued. They were corrective warnings regarding labels and the sinks and the drain. But the improvement that had been made in the sanitation standards, there weren't as many findings as prior inspections.
So there was some improvement from March to May.
There was some improvement, yes.
Please turn to exhibit 21.
Exhibit 21 are several documents relating to an investigation of unlicensed activity. The board takes in complaints relating to folks that are not licensed and offering services. During the course of an investigation, a staff member from the board identified the school in the background from one of the unlicensed person's posts. When the staff discovered that there was a tie to the school, we reached out to the school for assistance in helping to identify this individual so they could receive a cease and desist to stop practicing nail services without a license. During the course of this investigation, one staff member was doing the investigation pertaining to the unlicensed person, London, who we believe to be the niece of a staff member of the school. Another staff member had reached out to Denise, the owner, asking for their name and their full name and address. As these email exchanges were going on, the Instagram and the advertisements of the unlicensed person were being removed in real time with our request for information. Ultimately, we were told that they didn't know who that person was. We weren't provided any information, which led to the board issuing a subpoena to the school for documents surrounding a youth beauty boot camp that the school had provided in 2023 to, I believe, high school age students, where they were able to shadow or participate in some sort of cosmetology instruction at the school. From that boot camp, an unlicensed person began performing services out of their home.
So does the board, or under the rules, under the NRS and NAC, are you allowed to host those kind of things with high school students?
No, under the laws and regulations, any course that a school offers outside of the ones that we approve for licensure, they need approval from the board. In addition to that, if they're going to offer a course that doesn't end in licensure, so something like this that doesn't meet the minimum hour requirements, they're required to have disclaimers on their advertisements. We were able to find some old advertisements from this boot camp that didn't have any disclaimers or information to satisfy those requirements in the law for outside courses.
So the board issued a subpoena. Did they meet the deadlines of that subpoena?
Yes, the school did respond in time, in the time frame that the subpoena asked, but we weren't given, I believe, all the information we were looking for. We were essentially told that the school didn't keep records. They just provided some nonprofit information, I believe, and then a personal statement stating that no records were kept for this particular program.
So you mentioned that a student of this program, or a high school student, let me be clear, a high school student, not a student in the cosmetology school. You guys caught her. She attended this summer program, and then you guys found her practicing in her home?
Yes, she was offering nail services out of a private residence without any licensing.
Was she a minor?
I don't know if we were ever able to confirm that because we weren't given all of the information.
Thank you. Why does no records matter when the board is investigating unlicensed practice?
It matters because we can't, I believe with this particular person, we were not able to send them a cease and desist because we didn't have a full name or full address. The complaint that we received was lacking some of the required information. So we were leaning on the school for assistance since we believe they had some knowledge about this individual.
Was the individual related to somebody at the school?
We believe they were related to one of the instructors, the nail technology instructor,
Do you recall her name?
LaQuinta Newell.
Thank you. Please turn to Exhibit 22.
This exhibit discusses the findings from an inspection held at the school. There were no citations, just compliance reviews listed relating to posting licenses and some sanitation processes. I believe during this inspection, because there were so many students present, we went through a lot of their individual items and gave them almost mock inspections. So some of the issues related to implements versus equipment. We wanted to discuss and make sure that students were aware of proper sanitation protocols. Once they go on to be licensees, then they'll have the same type of inspections and be subject to citation. So we're trying to educate the students what an inspection would look like.
And so there were sanitation issues found during this.
Yes, there were items and equipment with debris that didn't appear to be either cleaned and disinfected appropriately or stored in a way that you would do it with our regulations.
Talk to me about the locked advanced esthetician equipment. This seems to be like an ongoing issue.
Yes, the advanced aesthetic equipment was locked in a room. If I'm not mistaken, it took some time for a staff member to be able to unlock that room for the inspection staff. And then I believe we were looking for other equipment that led us to the classroom outside of the school. We had concerns that there weren't enough microneedling pens, but we didn't do a full equipment count on that day. So we weren't sure if they were somewhere else or if they were in that cabinet in that photo. There was about 3, I believe, in there.
Could you clarify the difference between a compliance review and an inspection? Yeah, and like a compliance review and an inspection.
A compliance review is our terminology for some type of violation of our laws, whether we're treating it as a warning or we're using it to identify an issue that needs to be corrective or something that they maybe were unaware of. It's used as a it's a teaching tool versus a citation, which has a monetary penalty.
Thank you. Will you please turn to Exhibit 23?
Exhibit 23 they're from the same inspection, I believe, from the September 2025 inspection, where after the conclusion of the inspection, we noted some discrepancies on one particular student's time records. During the in-person inspection, there were a couple of students that could not be found, one of which we asked the staff members if they knew where the student had been, and nobody could really recall. And it was explained to us that if they had signed off on the performance sheets, that she had to have been there at some point, because that was one of their backup methods of attendance. So after the inspection concluded and we later received time records, we saw that the student the records had changed some from when we were there versus what had been included in their final time record. We noticed that the sign off on one of their records was strange. I believe the evening instructor had signed off on the performance sheet, but that person had been clocked in since, I believe, earlier that morning, 8 or 9 in the morning. So that instructor couldn't have supervised that student for the whole day. Just other time issues where they had been clocked in, not clocked in.
And then was there a student that couldn't be located?
This student couldn't be located while we were there.
What was the name of that student?
Her name was Yarasar. I'm probably not pronouncing that correctly.
Did that student get hours for the full day or?
That student got hours for the full day, and it looks as though their time records changed from when we had taken photographs or notes during the inspection versus what had been supplied to the board staff after the student completed.
Thank you. So, I was a little confused about this. So the school records were printed at the school around 3:30. The student's last recorded punch was 12:15, but the final records indicated punches for the student on that date occurring from 12 to 12:30. And no punches from 12:15 were recorded in the final time record.
Yes, so if you go to page 735, these records show what was taken on September 4th, 2025 during the inspection. This document that's labeled "You Attend" with the notes on it are records from the school's clock in and out biometric system, where we could not find this particular student, Yarasar, and we were there at approximately 3:30 to 4, and that person wasn't there. On the backup time records where students sign in and out, you can see that the last entry was at 3 by a student named Laura. And then if you fast forward to the sign in and out sheets that were then provided to the board by the school in December, you see that more records are added after the inspectors took a photograph of the handwritten sign in and out sheets, which it almost looks backdated. The last record that we had was at 3, and then it goes back to 8 a.m. The person's clock says that they left between 12 and 12:15, and then again at 3 and 4:30. But at our inspection, based on the time records from the You Attend system, that student had been clocked in, and we could not physically find them. And then if you look at those records again, which account for some of the final time record, you do not see those punches. So according to the biometric fingerprint scan time records, the student clocked in at 8:09 a.m., clocked out at 12 p.m., then back in at 12:30 p.m., presumably for a lunch break, and then back again at 6:30 p.m. But this is on a date that we were present at the school between the hours of 3:30 and 4, and that student is clocked in according to the records, but was not physically present for us to find at the school.
So just to be clear, the student received credit for a period that she was not at the school.
Yes,
And do we have an estimate of how long that was?
it would be impossible for us to know because the records are not reliable.
Thank you. Please turn to Exhibit 24.
Exhibit 24 is a recap and documents from a training that the board staff provided to the school. It just recaps what was discussed. It provides their hours of operation and some information about the programs and the staff. And I believe it has sign-offs on who had been present at the training.
Thank you. Please turn to Exhibit 25.
Exhibit 25.
Real quick, one question about 24. So the staff basically made clear the expectations that were set for them getting into compliance.
Yes, we believe that we were all on the same page after providing the training. It was reiterated if they had questions or concerns, the appropriate staff member to go to, and expectations moving forward.
Did they understand the consequences of not getting into compliance?
I believe they did. At the conclusion of that training, I spoke to Denise personally in her office, where I explained to her that the school has had some issues, and as board staff, there's only so much that's within board staff's power to do. As our executive director states many times, that we're not in the citation business, we're in the compliance business, and our goal is to get them into compliance. And that a lot of the issues that the school was having were out of our meeting staff, our ability to discipline for, and it's something that would have to go before the board members. So I was advised that if there were more issues, that it would become an issue that would have to be brought before the board because staff can only discipline on certain areas.
Thank you. Now on to Exhibit 25.
Exhibit 25.
Sorry.
You're fine. Let me know when you're ready.
Ready.
Exhibit 25 is just summing up some information from some previous inspections. The school, we attempted to do an inspection of the school on October 20th, towards the end of the business day, which proved to be a little chaotic. There was a lot of coming and going from students and staff. It was not clear who was working, who was coming back from lunch, and we weren't really getting a lot of clear answers or information from the staff that was present at the time. So the inspection essentially was not completed on that day, and we advised that we would come back. There was one thing that was noted, though. There was concerns about spray tan equipment found inside the room that was typically designated for the laser. We had some concerns about how that room was being used and shared with space that's not within our jurisdiction and how it might impact the proper functioning of that equipment and the laser, so that presents a safety hazard. So discusses October 25th, 2025 inspection. There was no instructor present at the school when the inspection staff went to complete their inspection. It's a requirement for a school to be open to have at least 2 licensed instructors present.
All right, let's go in reverse order on that one. What is the issue? Well, do you have to get approval to do spray tanning?
No, it's not something that falls within our jurisdiction. It's not in our scope of practice, so it's not something that the school should really be doing.
Okay.
And then there are safety concerns there's contraindications for providing a laser service over somebody that has a spray tan on them. It can be a serious injury risk. And there's also concern that the splatter, even though it's a fine mist from a spray tan, compromise either the room itself if it's not large enough or well ventilated, or impact the of the machine.
Now, I'm no expert, but don't you typically do a spray tan in like a tent?
You could do it in a tent or a machine. It looks to me like they had a tarp. So whoever's getting the spray tan could stand in front of the tarp and that would collect some of this fine mist splatter.
Why was it important that the medical officers sign off on the laser machine coming back out?
It was important to us because we felt that there was an issue. We did some research of our own to ensure that we weren't overreacting. Essentially, we wanted the healthcare professional to know what kind of condition where laser treatment services could be being executed was being shared with spray tan service or machine in the event that they had concerns about how it would impact the equipment.
So, was there an issue with sign-in sheets not being left out?
There were I believe from the October 20th inspection, that was part of the reason that the inspection really couldn't go very far. The staff that was present printed, I was the inspector for that inspection. So they printed screenshots what it looked like from her phone and it was duplicated. So it didn't look like the complete record. And there was a lot of students coming and going. There was no sign-in sheets anywhere to be found, but there were students that were engaging in hours. They were participating in classwork. And then there was missing instructors. I couldn't identify until towards the end of my time there who was supervising the cosmetology student that was present. And then towards the end, a staff member walked in and stated they were the substitute cosmetology instructor. And then the staff from the school advised that they had been there and they were on their break, but they had also told me that the program didn't start until 5. So I was just getting a lot of conflicting information about when, what, where. So there was no records for me to rely on. So I said I would come back.
So you asked a staff member about the correct start time and were you getting?
Yes. I don't know if we were not understanding each other and she was directing me on when a different program started versus when the cosmetology program started. But I was told that that instructor was on a break, but then I was also told that the program didn't start until 5. So that didn't align because it was about 4:50 when I got there.
What staff member were you in contact with?
I believe she was the registrar at the time, Angel Tellis.
Thank you. Please turn to Exhibit 26.
This exhibit discusses the outcomes specifically from the October 2025 inspection where there were no licensed instructors found on the premises. Again, I was the inspector for that particular inspection, so we completed on Saturday. We identified Latoya Webb at standing where the Cosmo instructor would typically stand, and I knew that she was not licensed instructor. I had just seen her enrollment paperwork for a provisional license from the day before, on a Friday, which is a day we're not typically open. So there were some concerns from that. And then I couldn't immediately identify another instructor. Someone told me they were an instructor. And then when I pulled them up in the system, they were not. And so ultimately the school had no instructors and they elected to close for the day because they couldn't be open pursuant to our laws and regulations.
So just to be clear, the school could have remained open that day if they had gotten the instructors there.
Yes, I advised Latoya that if they could submit her enrollment for her provisional instructor, that would count towards the attendance of the instructors and that I would process it there because I had my work laptop on me. There was no pending enrollment for her and I didn't receive one. And then all they would need to do was get one other instructor to come and be present. And I believe the owner decided not to do that and they were just going to close for the remainder of the day.
So, did you observe any students leaving the school?
Yes, while I was there, there before identifying the instructor issue, a student left before I began my inspection, and then the missing instructors took precedent. So while they were sorting that out, I went around and I just photographed everybody's name tag so I could take their attendance because I didn't have a record from their biometric system. And then some students started to leave. Others were in the middle of services and wrapping things up. There was confusion. So everyone kind of trickled out at a different rate.
So for Sally Ross, did she get time for when she wasn't, did she get time credited for not
Yes.
being at the school?
That student left when I first arrived at the school and we had difficulty identifying her. And then she happened to just walk back in towards the end of the inspection. She was not clocked out according to her time records and she was not present in the school.
Thank you. Do you know off the top of your head which statutes require supervision and instructors?
NRS 644A 735 is one of them. That states specifically you need a staff of at least 2 instructors. There's other regulations that speak to having an adequate amount of instructors per branch of cosmetology that you wish to instruct, but that's the main one that we rely on. It's in our schedule of fines to cite to. Fines.
Was there an issue with the laser again?
I believe the laser had been placed back in the room on that inspection. So we had initially asked that the school get a letter from the healthcare professional before it go back there. And if I'm not mistaken, it was found in that room again. And we had not received the letter from the healthcare professional.
So it wasn't signed off.
No, we'd not received the sign off.
Now, I may have asked you this before, but just again for clarification, when school records are late, missing, or unreliable, can that stop a student from testing?
Yes.
Yes, it does, or sometimes.
If we are aware that they're unreliable or they're missing, they're incomplete, then it will stop them because we can't verify the information.
Can students fix the portal records themselves, or do they depend on the school for that?
No, for the school portal, that's something that basically links directly into our licensing system. So only staff of a licensed school would have access to that. We rely on that for communicating enrollments, completions, withdrawals, and practical scores. There are other requirements of a school to keep other records for a student. Those are just the most basic records.
Do you know off the top of your head how many students have not been able to sit for the examination who have graduated from the school?
Off the top of my head, probably 30.
And how do they rectify that?
They can petition to appear before the board and get these specific students that have been several times and had done the best we can to try to give them letter credit, the additional hours, so they can sit for their exam.
And this may be a question that's more appropriate for Bertha, but please rebuff me if it is. Um, if a student graduates from cosmetology school and there are discrepancies in their hours, how, I mean, like, how do they, like, what is the process for rectifying that?
That's a question better suited for Bertha.
In your experience, do sanitation, equipment, and supervision problems affect student training and public safety?
Yes, if a student is not trained on sanitation, then they will not know the proper procedures for practice for when they are licensed in a licensed establishment. If there are issues with the required equipment either being accessible to them or exposed to the required curriculum that they need to know to safely perform services on the public when they become licensed.
Thank you. So for right now, I'm done, but I would like to get with staff and see if there's any more questions. I think this would be a really good time to break for lunch. And lunch is here.
All right, let's go ahead and break for lunch. The time is 12:12. Let's plan to be back here. Should we do 30 minutes?
Well, we're
Oh.
gonna, unless you brought lunch for me, I'm gonna probably, I don't know if I can get across the street and back in that time. So I mean, I
Okay.
can try, but,
We can make it 1.
We can make it a 1 o'clock return time.
okay.
Yeah, about 45 minutes.
Thank you. I'm not trying to delay it.
No
I'll be
worries.
back as quick as I can, but
Absolutely.
the only other thing I would say is witness is in the middle of her testimony, that she not be allowed to, she's in the middle of her testimony. If we were in any legal proceeding in this state, normally you're not allowed to talk to anybody when you're in the middle of your testimony.
With that in mind, may I have a minute for the executive director and we could probably we might be able to close.
Yes,
it up.
let's
But
pause
actually,
lunch.
You're gonna.
Well,
have
I'm
to
gonna
pause.
cross-examine
Yeah,
her, so she's,
It does.
I'm sorry.
Sorry.
I will be cross-examining her, so I think, I mean, I don't have a problem with you asking questions when we get back. It's just typically it would not be appropriate for her to be speaking to you or the staff or the board or anybody
I agree.
in the middle of her testimony.
That's fair.
You're asking for her to be.
Just more
sequestered?
counsel can agree. I agree.
That's fine.
Okay. Thank you.
Did you, yeah. Joseph, did you still need to talk to her before we break then?
No, I think we're good.
You're okay? All right, then we are going to break for lunch. We will be back at 1 p.m. Thank you, everyone.
Yes, I only have one question left for Miss Huggins. Um, good afternoon, Miss Huggins. I just want to remind you that you're still under oath. Um, the square footage concern for the advanced school esthetician, was that a huge concern for the board?
No, it's not a huge concern for the board. It's something that just needs to be addressed and rectified. There are different paths on how you would come up with a solution. Typically, we would recommend a variance. It's part of today's proceedings because it may bear an outcome in the discipline.
Thank you, Miss Huggins. That's all my questions for now.
At this time, if you would like to ask our witness any questions, you may do so. Okay,
Yes, thank
go
you.
ahead. Yeah.
Usually people can hear me, so I'm have a loud voice. It's not meant to be
Where's she gonna pull up?
loud, but it is.
There it is. Sorry.
Good afternoon, Ms. Huggins. I'd like to take this opportunity to go through, follow up on some of the answers you gave previously. One of the things that I did not catch, though, was how long you've been serving as a staff member to the board. Can you just, if you said that, I missed it, and I'm sorry.
That's okay. I've been employed with the board since September of 2019, and I've been the chief compliance officer since November of 2022.
Thank you. So would it be fair to say that you have been involved and a part of the staff for the board during the time when the board transitioned to a new portal for student enrollment?
No. We still have the same portal and licensing system that we've had since I started. But you may be referring to process changes that have been updated over time.
Well, it's my understanding that at some point in time, there was some type of transition by the cosmetology board to a different enrollment system that when you move, it's when you moved offices. When did the board move offices?
Prior to my employment starting here.
Okay. And you started in September of 2019.
Yes.
So they've been using the MOVAD system since you've been here?
I'm sorry.
What is the name of the portal that is used by the school to keep track of student enrollment?
We call it the school portal and the NV Cosmo portal. It's in-house software.
And okay. And you're not aware of the fact that multiple schools at one point in time had major issues when with enrollments that they had put in the system, dropping off and not appearing in the system? You weren't a part of that? You weren't here when that occurred?
I believe that in our current system, as we move forward in a data migration to a new system, there have been issues and components with our current system not operating properly, and we've modified processes, but it's still the same system, if that answers your question.
Okay, that might be good. Yeah, because I thought it was a new system. There were just modifications to the system, correct?
Yes.
And the modifications that were made to the board, to the board's portal system created enrollment issues that impacted many, many schools. Isn't that true?
Yes.
Yes. And in fact, students were appearing in the portal, let's say for school X, but they never were enrolled in school X. They were actually enrolled in school Y. So there were major problems at one point in time, weren't there?
No, I'm not familiar with that being a problem.
So if I called in owners of other cosmetology schools that would testify to that, they had that problem and my client testified, and I were to subpoena multiple other witnesses that are school owners and operators, you don't think they're going to tell me that their problems existed that I just explained?
I'm not aware of those problems. I'm
But you're
aware
not
of
denying that they exist.
other problems. I don't know anything about those problems.
Okay. My client has been cooperative throughout this entire process since she was initially licensed, hasn't she?
Could you be more specific?
I don't see anywhere in these records that indicate that my client has been uncooperative
With what? Could you be more
with
specific?
anything.
Sure.
You agree that she has been cooperative, is that correct?
Yes, with what though?
Objection too broad.
Can you point, I'm just talking in general sense. I mean, you're trying to revoke this lady's livelihood. And she's been in this business for almost 11 years. She's been renewed, this board has approved her license 6 times. And everything I've read suggests that she's been cooperative over the last almost 11 years. Do you agree with that statement?
There have been times where she's cooperative. There have been times where she's not.
What has she not been cooperative about?
That's probably a question better for other staff members, but we've had difficulty obtaining records with her during this process.
Anything else?
Nothing else comes to mind.
Well, you understand we're here today at this here notice to revoke her license for 10 years. So I'm sure you came prepared today, right?
Yes.
In the complaint, did you have any part in drafting the complaint?
Yes, I participated in that.
Who else drafted the complaint?
Joseph Estunio, Stephen McDonald.
Okay, so as far as board staff, it would be you and the executive director, Mr. McDonald, correct?
Yes, and other staff members.
Okay, who else?
Bertha Jackson, Lauren Gossage, Erica Swick.
Okay. And in the complaint, it indicates that the staff became aware of my client's misdemeanor plea agreement that occurred back in 2018. The complaint indicates that you learned that it came in December of 2025, almost 10 and a half years after she was initially licensed. You aware that's what the complaint says?
Yes.
How did that come to the attention of the staff in December of 2025?
I don't know, to be honest with you. I believe staff found it through public records, open source information.
Well, I'm entitled to cross-examine whoever found that, and who would know? So I can ask that witness.
Bertha Jackson.
Bertha Jackson found it?
I believe so.
Okay. And tell me about what happened when she found it. Tell me how that occurred.
I was not present on the day that was found.
Okay, well, tell me what you understand happened.
I understand that they found that Denise has some sort of criminal charge or record for bad record keeping. And outside of that, I don't know.
Okay, and was that relevant to you?
The records portion of it aligns a little bit with the issues that we're here for today?
Well,
Hold on. I want to object because I didn't ask her questions about this cross-examination.
okay, well, you want me to recall her later and in my case in chief, I'm happy to do that, but
I mean,
I'm
you
gonna
didn't-
ask these questions. They're in what you did was you put in an exhibit book with over 1,000 pages of exhibits and you want to take this beautiful woman's livelihood away and I'm entitled to ask questions about everything in this exhibit book.
Well, you didn't give me a witness list. So
You didn't
if you
give me one either.
you didn't request one, the statute. Sorry. Can you say that? Repeat what you said.
I'm sorry, I'm not trying to be difficult. I'm just trying to say that I like to ask questions about the exhibits that I was kind enough to stipulate into evidence, but I want to ask questions about it. And I want to ask questions about the complaint that was filed in this case on January 29th, 2026, when my clients had just been given training, had just been given a guidelines to follow, had just updated her standard operating procedures and thought everything was good to go. And so I'm just a little confused as to why you would have a problem with me asking about something that's in your complaint and in your 1,000+ pages of exhibits. I would like the board to know the truth about what's going on here.
NRS 622A requires that you request the witness list, which I provided for you this morning verbally because you didn't reach out to me. My contact information is in the complaint. And I didn't bring up the Medicaid fraud. I might bring it up after your client testifies as impeachment evidence, but I think it's improper at this time that you're questioning her about it.
Well, I don't know why.
I think
you
it's
find-
very
First off, I'm
premature.
not at least bit concerned that you didn't provide me with your witness list. I'm fully prepared to question any witness about anything that has anything to do with this because it matters to my client. So I'm not concerned about that. I'm concerned about why you have a problem with me asking this witness question about an exhibit that you put in the evidence and about a paragraph that you put in this complaint.
Like I said before, this is cross-examination. I don't mind you crossing her about questions that I asked, but I think it's premature to bring up things that were not brought up.
Well, I disagree because it's stipulated into evidence and it's part of your charging document.
But that you agreed to that.
This is Senior DAG Todd Weiss. So there's one of two things we can do here. We can limit counsel's cross to the questions that were asked on direct by Mr. Ostunio, and then she can recall the witness to ask questions on direct or in her case in chief, or we can allow her to ask all of her direct questions during the cross, and that way the witness only has to answer questions one time.
Well, that's what I was going to try to do
But
rather than.
but that was never discussed ahead of time, counsel.
Okay.
So we need to. So we need to decide how we're going to do that right now, so there's no confusion.
Well, I am happy to do it in whatever way we all agree on. I think I'm trying to do it in the most efficient way for the board. And to me, that makes sense to go through these exhibits as few as times as possible. That's what I would have proposed. I mean, I've been a trial lawyer for 36 years. Usually regulatory proceedings are normally more lax than court proceedings. So
No,
not
they generally are.
I don't care what way we do it, but I'm gonna ask the question.
Yeah.
Tell me how you want it.
Okay. So I'm gonna withdraw my initial objection. I'm gonna allow her to proceed, but I'm gonna object and say asked and answered. She has answered your question and you keep pressing her on it.
Well, at this point, I don't even remember my question, but I think about it. So,
Do you need the court reporter to read back your last question?
no, I'm okay. We're gonna move forward from here. Let me just come up with another question. I guess we need clarification. So I can go into anything that relates to this complaint now. I don't want to keep having this issue, or we're going to save those questions for us later in the day and I come back with a second list of questions.
I'm not gonna object to you bringing up anything in the complaint for time restriction, purely for time.
Thank you so much.
You're welcome.
So as the chief compliance officer, you work closely with the Attorney General's office?
For hearings like today with the complaints, yes.
And the Attorney General's office has been the lawyers that represent the board.
Yes.
And that's been since way back in time, right? Okay, so for the entirety of the time that my client has had this license and all these renewals, the Attorney General's office has been representing the board? Okay, and of course, the Attorney General's office is the one that filed the criminal complaint that is referenced regarding my client back in 2018, isn't that correct? And so the Attorney General's office would be well aware of that issue back in 2018, wouldn't they?
I'm sure in 2018 they were well aware of it. Yes.
Okay. Nowhere in the cosmetology licensing rules or regulations does it say if you have a misdemeanor conviction that you can't apply for a license and be licensed, does it?
It doesn't speak specifically to misdemeanors. It does speak to good moral character and ethics.
Okay. And as the chief compliance officer from September of 2019 to the present, part of your job is to ensure that your applicants and renewal applicants have good moral character and integrity, aren't they?
School owners and operators, I believe that's an initial licensing question, not a renewal.
Okay. Nowhere on any license does it say that, and nowhere on any cosmetology application or renewal does it say, ask you, do you have any misdemeanor convictions? Does it? And nowhere during the course of the almost 11 years that my client has been licensed has anybody asked my client about whether she has a misdemeanor conviction. Isn't that true? To your knowledge?
To my knowledge.
So when you say in the complaint that my client failed, somehow misled this board about failing to disclose some misdemeanor conviction that they should have known about all these years, there was no affirmative obligation in the law for her to tell you about that, was there?
Objection. That calls for a legal conclusion.
You're the chief compliance officer. Correct?
Correct.
Since 2022, correct?
Correct.
So you've been the chief compliance officer for her fourth renewal of her license in March of 23, correct? And you were the chief compliance officer for her fifth renewal in March of 2025, weren't you?
Correct.
And you never did a Google search to see if she had a criminal record?
No.
And apparently nobody in the staff did a Google search from the time she was licensed in March of 2015 until December of 2025 to see if she had a criminal record?
We have 40,000 plus licensees. We can't Google them all one by one.
Okay, I'm just wondering if you answer my question now. Nobody, to your knowledge, did a Google search or cared enough to determine whether she had a misdemeanor conviction for any of the 6 licensing time periods?
No.
But now it's somehow relevant?
Objection. Calls for a legal conclusion.
Okay, I'll move on. In fact, you're aware that my client does not have a felony conviction, aren't you?
Yes, I believe it's a gross misdemeanor, not a felony in this case.
I
Yes.
mean, it's a misdemeanor.
Okay.
Okay. Are you aware that the cosmetology board licenses people that have felony convictions?
Yes, there are some licensees with felony convictions.
And in fact, there's a specific form on the board's website that talks about a licensee, an applicant that has a felony conviction, and it gives them all the information that they need and are obligated to provide if they want to get a license if they have a felony conviction. You're aware of that, aren't you?
Correct.
There's no form similar to this for someone that has a misdemeanor conviction, is there?
No.
I'm gonna, want to admit these as exhibits. You don't have
Do
any.
you have copies
objection?
for me?
I don't, I can make him, I'm sure, I should make them.
I'll look it up real quick.
Oh, good.
Okay. Now, let's, while we're waiting for those,
1 sec.
oh,
Chair needs to admit the exhibits you just.
okay, I was.
Well, actually, hold on. Let's wait until they have copies.
Yeah, that's fine. You, if you want,
Sorry.
Oh, you're fine. No, you're right.
One copy. Thank you.
absolutely, yeah. I'm sorry, and if I don't, I'm gonna try and remind you. I'm not doing it on purpose. I get on a roll. How would you like to make this an exhibit? You want to just go with the next number?
Yeah, would that be easier?
A collectively A, or A, 3 pages of A? Okay.
And then I can report them,
So,
right?
yep.
Okay, so moved.
At this time, I'd like to offer, file, and introduce into evidence, Exhibit A, which are 3 pages of these 3 awards. At this time, I'd like to offer, file, and introduce into evidence Exhibit A, which are the 3 awards that I want to discuss with the witness.
So moved.
Do you need copies?
I will.
Okay.
Are they do you stipulate them into evidence?
They've already admitted counsel.
They're admitted?
Yeah.
Okay, I'm sorry, just checking my boxes. Now, your goal today is to revoke this lady's license for at least 10 years, correct? That's one of your goals that you're going to request?
Jack, for the record, that is the maximum.
Okay, well, that's my.
We haven't made our recommendation. I'll be completely honest with you. I don't think we're gonna ask for the full, but yeah.
Okay, well, I appreciate that. That would be nice, but I appreciate that clarification.
I mean-
Let me rephrase my question. Okay, I'm happy to rephrase it. In the complaint, the punishment that you're seeking, one of the punishments that the staff is seeking is to revoke my client's license for anywhere from 0 to 1 year to 10 years. Isn't that what the complaint says? Do you need to look at it?
No, I know what it says, but I defer to what Joseph said. It's
Okay, but that's what you're asking. It says in the complaint, one of the things you could be asking for is up to 10 years, correct?
Yeah, but that's what the statute
Okay.
was. We're just regurgitating the statute.
So what's your recommendation as a staff member and chief compliance officer? Your personal recommendation?
That's not in my purview.
And who decides that? Is it the executive director?
The board is the one that has the final say.
Okay, but the board, but the staff recommends something. And I'm trying to figure out what that recommendation is going to be while I'm still asking questions. So who on this staff is recommending that? so that I can ask them about what their recommendation is and what it is based on.
I mean, I'm gonna object because like this, we could have had this conversation over the weekend and I could have called and gotten you some clarification and we probably could have reached a settlement, maybe, possibly, but like.
Well, if you
wait,
want to reconvene,
no, I'm absolutely not. Like today's the day. Like we prepared for this. I'd like to proceed, but I think this is a very inappropriate question. And I'm going to object.
Okay, well, that's not a legal objection, so you can answer my question.
You're,
You are the,
are you asking her as in her personal, like from a personal perspective, or are you asking her as board staff?
well, the staff is the plaintiff in this case.
I think she's asked and answered the question when she said that that's not in like part of what she does.
So you don't have a recommendation as to whether her license should be revoked or not?
Not at this time, no.
Okay, so you're the chief compliance officer and you have no recommendation as whether it should be revoked or not revoked. Is that correct?
Not at this time, no.
Well, today is the time to tell us.
It's the decision for the board.
Okay, now I'm gonna show you, how do we get exhibit this to the witness? Okay. I'll show you what's been accepted into evidence as Exhibit A. Were you aware of, we'll start with the first page, which is the Urban Chamber of Commerce Award in 2019. Were you aware that the Cosmetology Institute of Las Vegas got this award?
No.
Do you have a lot of schools that you license that have these types of awards?
I do not know.
So
What is this relevant?
no, it's relevant. It talks about integrity and moral fitness to be a licensee.
So are you rehabilitating the witness that hasn't been called yet? I'm a little confused.
Well, I'm a little confused why you need to keep interrupting me because
Objecting.
what typically a
Relevance.
relevance, it goes to the fact that you have attached to your complaint a misdemeanor from 8 years.
I'll withdraw the objection.
Okay. So the next part of this, Best of Las Vegas, they got the best trade technical school in Las Vegas, according to the Las Vegas Review Journal in 2021. Were you aware of that?
No.
Does that impress you?
No.
Do you have many other cosmetology schools that get awards like this?
I do not know.
What about the next one where Nevada Decision Makers Magazine gives her this award in 2020? Did you know about that?
No.
Let's go to Exhibit 1. Exhibit 1 is the initial license that was issued by this board for cosmetology license back in March 23rd, 2015. Is that correct?
Yes.
Okay. And tell me the branches of cosmetology.
Nail technology, aesthetics, hair design, and hair braiding, and advanced aesthetics.
What is the Cosmetology School of Las Vegas licensed? What is their license?
Do you want to know for when they were initially licensed or for now, for
I
today?
want to know the progression.
When they were initially licensed, I believe they were licensed for the cosmetology program.
Okay, and that was in March 23rd of 2015.
Correct.
And then for the first renewal in 2017, what was that license renewal for?
You'll have to give me a moment to pull up the
That's- And while you're checking these, could you just confirm that the address is the same on the original versus all renewals? Please, so I don't have to go back over it.
License that appears to have been issued in 2017. Address is 3249 West Craig Road, Suite 100. And I believe the services that the school was licensed for this time were still cosmetology.
Okay, and that address you provided is the same address as on the initial application in 2015?
Yes.
Okay, the second renewal was in 2019. What's the license and address for that? Is it the same?
The license that was renewed in 2019, same address and services taught cosmetology.
Okay, so it's the same.
Mhm.
Okay. Third renewal? Which was in 2021. With the same physical location, same square footage, and the same services that she's licensed to provide each.
It is the same physical address and the services. My apologies. I'm having difficulty locating the one that occurred in 2021. I think it might have been late and actually occurred in 2022, but if you have
Okay,
a date that you'd like me to check, I can.
Well, let me just ask you this. Is it the staff's position that the physical location and square footage has remained the same in the entirety of all these licenses?
Yes.
Okay, and is it also your understanding that my client has had been licensed since the beginning to teach cosmetology, all branches? Well, let me back up. She's been licensed to teach cosmetology and which included the branches that existed at the time, and that at some point when advanced aesthetics became part of an additional branch that her license was supplemented to add a license for that as well.
There was a point in time where she added on that program. Yes.
Okay, that's all I'm trying to establish. Okay. So, and And what is the square footage of her physical location that she's had for almost 11 years now? That's never changed?
I believe it's somewhere between 5,000 and 6,000 square feet.
I told you it was 5,906 square feet. Would that sound about right to you?
Yes.
During the renewal process of renewal licenses, the staff and the board have some obligations regarding those renewals, or just, or if they just have no obligations when that gets submitted? Okay, well, does the law require the staff to make sure that the licensee still should be licensed when they renew it? Or do they just take the money and ignore any job obligations?
Upon renewal, there are things that have to be submitted, like updated contract to verify their instructor staff.
And my client has complied with all the obligations that the law requires for the initial application and all of her 5 renewals since the initial application, hasn't she?
For the renewals, yes.
And
the
for the
initial,
original.
correct.
The square footage issue is part of the complaint, isn't it?
I believe so, yes.
Okay, so are you asking this board to, as part of the basis to revoke my client's license based on her square footage?
I think the concern with the square footage
Yes
is,
or no?
could you repeat your question?
Are you asking this board to revoke her license in part based on the square footage issue? Yes or no? And then you can explain.
I really don't want to object, but here's the thing. You're asking her a question that it's not like she's not here to make that conclusion. Like that's not part of, and I think she's already addressed that. Like
She can answer my question now. Thank you.
I know that the square footage is an issue.
Actually,
I'm not-
no, the chair needs to rule on my objection. So my objection is that she's asking her to basically tell her what the board's position is, and that's an inappropriate.
No, I'm not. If you understand that to be the case,
Well, then
that's not,
could you rephrase the question then? Okay.
as I understand it, the board is the decision maker here today. The staff has submitted the complaint. So the staff is effectively the plaintiff. Is that correct? The board is not the plaintiff. The board's like the judge.
The board actually.
The board is deciding what they're gonna do with this.
Counsel, the prosecutor makes those determinations, not the board staff. The prosecutor is in charge of,
The attorney.
correct, the
Okay,
prosecutor.
okay.
And Janie is not in a position where she makes recommendations to the board. That would be the executive director and myself.
Okay, I understand that, but I mean, I am entitled to know whether, I mean, maybe it might be simpler if you just say.
You're asking her in her job role, and that's where I'm having the issue. Like, if you're asking her personally what she thinks, that's different, but like.
Well, someone speaks for this plaintiff in this case. Someone speaks, and I'm entitled to ask whoever speaks for this plaintiff. You can't just say, well, he can't do it and he can't do it, and nobody can tell me the answer to this question. I'm entitled to my client due process, and I'm just simply asking a very simple question is this allegation that is in the complaint, if it weren't in the complaint, I wouldn't be asking the question. Are you continuing to be asking the board to make my client pay fines, make my client make some corrective action, and or revoke her license, any of those things based on this square footage issue? That's all I'm trying to say, because what I am hearing from this witness, and I think from you, is no, we kind of put it in the complaint, but we're not really asking for that. If that's the case, then let's have a stipulation right now that the square footage issue is a non-issue for this today, for this.
I'm
Here-
not going to agree to that, but you're basically asking Janie to speak for the board, and that's where I'm having the issue. It's the board's decision whether that allegation is going to ultimately decide whether or not they revoke her license for 10 years. But I mean, I don't know like how you expect Janie to answer that. That's an inappropriate question.
Let me ask you this. You're the chief compliance officer, and that means that you're the compliance officer for every licensed school in the state of Nevada, correct?
Yes.
Okay. So let's go through this list. Well, let me just, before I get to the list, how many square feet does the staff believe my client should have for the things that you have licensed her for? How many square feet are you telling is my client supposed to have? I mean, you licensed her 6 times. She's always had 5,906 square feet. You found a need to put this in the complaint. She's never changed her square footage. The only school she teaches is cosmetology. All her branches are within cosmetology. So what square footage is it that the plaintiffs in this case are claiming that my client should have because they've never told her that?
In late 2024, the laws changed that require every school to have the corresponding square footage for every program they're licensed for. So if you're licensed for cosmetology programs and aesthetics programs and nail technology programs and advanced aesthetic programs and hair design programs, you have to now meet the equipment and square footage requirements for all of those programs individually.
So that would be 14,500 square feet?
Somewhere in that ballpark,
Well,
yes.
let's just not talk ballpark. Let's not talk ballpark, let's talk specifics. So you're saying that the plaintiffs in this case interpretation of the statute is that my client would have to have 18,000 square feet because the statute, according to the plaintiff's interpretation, is that cosmetology requires 5,000. And you've got to add 3,500 for hair design and 3,500 more square feet for estheticians general. And then 2,500 square feet for nail tech. And then another 3,500 for advanced estheticians, which makes the total square footage required for anybody with that teaches all branches of cosmetology, 18,000 square feet. Is that your understanding of the case, the statute?
Yes.
And does any school that the board has currently licensed have 18,000 square feet?
Yes.
Who?
I believe Euphoria is over 18,000 square feet. NEMA is over 18,000 square feet.
Euphoria and who else?
NEMA, I believe Sierra Academy of Style is also somewhere in the 20,000 square foot range, but it's per program that the school offers. So not all schools are licensed for and execute all programs.
Okay, well, Academy of Hair and Design is licensed for all cosmetology programs, including advanced aesthetics, aren't they?
No,
How many square feet do they have?
I don't know, to be honest with you, but they're not licensed for all the programs.
They're licensed for cosmetology, aren't they?
Yes, but they're not licensed for advanced aesthetics.
Okay, so it according to the statute, then, if somebody is advanced, according to the plaintiffs in this case, interpretation of the law, any school that is licensed that does cosmetology, has a cosmetology license, but not an advanced esthetician license, has to have 14,500 square feet. Is that correct?
No.
How many do they have to have?
It depends on the programs. So we have a cosmetology program where a student would take the 1,600-hour program. You can also have a nail technology program for just nails. You can have an aesthetics program for just aesthetics, an advanced aesthetics program for just advanced aesthetics, so on and so forth. Not every school has every individual single program.
And I understand that that's the case, and I think, you know, some of the board members that were on the board back when this law went into change was made will remember that it was made because you had, for example, schools that wanted to get licensed as nail technician schools, but they didn't want to do the others, so they wanted to be able to have only the 2,500 square feet, for example, for a nail tech school, and not the other square footage. They don't need 5,000 square feet. There were.
I think you're speaking to when the law was like initially put in our chapter, not the most recent regulation change that says that you have to have all the programs
So when did that change take place?
in 2024.
Okay, and when did the initial change take place?
I couldn't, in the 80s probably.
Okay. So even though this change took place in 2024, you're continuing, the board and the staff are continuing to renew licenses that you believe do not comply with the square footage requirements of the new law?
There's no metric by someone on the square footage. It would be some. We can't deny a renewal without getting the board involved. We can't revoke a license. That's all within the board's.
Okay. So one of the things in their purview that we could leave today with would be that the board hereby agrees to grant my client a variance to remain in her building and continue with all the programs that this board is licensed her to be in that square footage. That could be one outcome from today, couldn't it be?
That is what the schools that are deficient in square footage currently, they all to.
Okay. And so it wouldn't be a problem if it was either granted today or we came back and asked for a variance. That would be something the board that could consider.
Correct.
Okay. Now let's look to Exhibit 2. Bates number 6.
Give it to the top. Oh, you can't because you're sharing.
I have it up. Want to ask me or if you want to wait?
Well, the board would probably want to follow along.
They have it in front.
Oh, you have it up there. Okay.
Mhm.
Oh, perfect. Okay. So on Bates number 6 here, this says at the top, school portal account audits, and that is an email that came from you. Is that correct?
Yes.
And that was back on November 6th of 2019. Is that correct?
Yes.
So any issues in this audit would have occurred in November of 2019, correct?
Yes.
Okay, and of course, we've already established that this board has renewed her license 3 times since that date. Isn't that correct?
Yes.
And the first line of this email says, "Hello, ladies." It's addressed to Denise Dixon and Charlotte Williams, who's sitting right here, works for the school. It says the audit has been performed on all of the schools in this school portal. So this wasn't just an audit done specifically for my client.
No, we audit all the schools.
All schools. Okay, now let's look at the next page. Then the next page shows that there are 30 on Bates number 7. It shows that there are 38 students listed on this list. Isn't that correct?
It's not numbered, but I'll take your word for it.
Okay. And that's the number I count. And there's well, let's go through these because why is this in here? Why is this part of this complaint since it was resolved in 2019 and you've issued 3 renewals since that time?
I don't believe that it was properly resolved, and that's why it's in the complaint. I think also the historical records from 2019 and 2020 and so on and so forth go to show a systematic issue with the school's records.
Okay, well, let's see what the issue was with this record. Okay, because in this record, this record, we've got student number one. What ended up happening with student number one? Student number one, what happened? Do you know what happened?
You would like me to go through the entire list of students?
Well, if you want to go through the entire list, I don't think you brought anything out regarding the entire list, because as far as I understand it, regarding this list, which is base number 7, that has 38 students on it. My reading of this whole exhibit number 2 is that there's only 2 that are inaccurate, 2 that are incomplete, and 2 that are accurate that you pointed out, and nothing inaccurate. There's 2 incompletes. There's no false information. So you're talking about, let's say 34 of the students on here, at least you would admit, are all proper, correct? Because you're only pointing out 4 students.
Correct. There are 4 students that have been
Okay.
pointed out.
So do you know what happened with student number 1, Henrietta York? Are you aware that Henrietta York enrolled in the instructor training program and decided not to do it? And so it was a clerical error and that it just hadn't been withdrawn. Do you remember that being the resolution of it?
That is actually the purpose for the issue, because according to our laws, if a student withdraws from a program, completes a program, then within 15 days, their final time record has to be submitted. It would be submitted. These records that you're pointing out, like Henrietta York, there's no final time record. It's never been submitted to us.
Okay.
I'm not saying it's
Well, she
incorrect.
didn't-
I'm saying
she
it wasn't
didn't
done.
complete the program.
It's I'm not saying that it's incorrect, that there's a typographical error, I believe you said. I'm saying it wasn't done. Our regulations require that a withdrawal or a completion be submitted within 15 days.
Okay. So what you found back in 2019 is that there were clerical errors on 2 of these students of the 38. That's what my records show here.
No. The purpose of this audit was to highlight students that had not been completed or withdrawn from the school system within a timely record. So if I'm not mistaken, the person that pulled the report pulled the list of what we called unaccounted for students. So they were in the system for several months without a completion or withdrawal, which means we didn't know what their status was. It's possible, and in some cases, I'm sure some of these students were just finishing their program. There are other issues that the purpose of the audit was to point out that if they had been withdrawn in the school or completed, that they needed to be completed and withdrawn in the system.
Okay. So in this audit, and so are you suggesting that, well, let me ask you, since this was sent to all schools, did other schools have 2 to 4 errors in their portal audit?
I don't have those records in front of me, but I'm sure there were issues as well.
My client wasn't the only one that had portal issues.
Most likely.
Now, exhibit number 3. This is the compliance. This letter was sent February 1st of 2020. Is that correct?
Yes.
Okay. And that's when COVID was all getting started, right?
Correct.
Okay. Now let's go to exhibit number 4. Exhibit number 4, I just want to get some, clarify what you testified to. Exhibit number 4, dealt with, deals with 4 people. So far in the first one we dealt with, or, this is 4 people. And the issue with this person, Alice Liu, L-U, was that she didn't have a social security number. It wasn't that it was input wrong. She didn't have one because she had her green card. And in fact, what this exhibit shows is that the staff didn't know how to properly get this in the portal either because she didn't have a social security number. Is that correct?
We don't put students in the portal.
Okay, isn't it correct that this exhibit shows that the staff was unsure how to deal with this student because she did not have a social security number?
No, I don't believe that's what occurred.
Okay, well, that's,
If I'm not mistaken, I believe that they weren't sure how to proceed because we didn't know where the initial number had come from.
I think it's. What do you do when somebody doesn't have a social security number?
You
What's the
have
process?
you have to have a unique identifier to enroll them into the portal.
And is that what happened with this student?
I believe that it ended up being the green card number.
And so that got resolved and the student was able to go on and take the program.
I think there might have been other issues, if I'm not mistaken.
Well, they're not in this binder, are they?
The hours.
This student's issues, other than the no social security number, are not a matter before this board today, is it? The only thing in this exhibit is talking about this student not having a social security number and everybody trying to figure out what to do about that. Isn't that true?
No, I think there were concerns with the students' hours.
It's not an exhibit. This exhibit is.
I believe it is.
Where's that?
It goes on to Bates 24, 25, 26. I think that the issue illuminated in that email was the beginning factor for the concerns for the hours.
Okay, and the number of hours that were taken during COVID.
Correct.
Okay, and that eventually got resolved, didn't it?
I believe the board I believe they made the board revote to clarify.
Because initially there was a lot of confusion about it and then the board clarified it. That's my understanding. And yours too.
No. I believe it was clear when they initially voted on what hours. I think at the time it was unclear what path we were supposed to take when we were in the state of an emergency. Everyone was navigating a lot of different things at this time.
Okay. And the second student on this list, which is on base number 35, that's the Kim Sim Tram. And one of the issues with this, as you can see on base number 36, is that I guess this is a Vietnamese person, and they didn't know whether the Phi Kim, what the first versus last name was. Isn't that what base number 36 is indicating?
Yes, it appears that the name was entered incorrectly as well.
Because it was unclear for this Vietnamese applicant whether what was the first versus the middle versus the last name. Is that your understanding?
I don't understand your question.
That's what this reflects. Is there was confusion as to what was the first versus the middle name, correct?
No, the documents,
This
the identification that was supplied to us by the applicant didn't match what was entered into the school portal.
And okay, but that is the issue, is the Vietnamese name.
No.
This on this document.
The issue is that the name that was put into the school portal didn't match the identification.
So you want to revoke my client's license because she thought that B was the first name and Sim was the first name? For a
What is-
Vietnamese person?
What is your specific question?
That is it.
Go ahead and
Part
repeat
of
it.
the basis you want to revoke my license is because someone working in her office had an innocent mistake for a Vietnamese name and mistakenly. put
Objection. You're rephrasing her testimony.
Them on Bates number 36.
Objection. The attorney is trying to rephrase her testimony.
Go ahead, you can answer.
What is your question?
No. Hold on. Whoa. She needs to make a ruling, and you cannot tell her that she needs to answer. That is very inappropriate, and I'm objecting to that as well.
Well, I would like you to stop making speaking objections. If we're going to go through a legal process here, then let's.
Excuse me, you've tried to rephrase her testimony now 3 times.
I'm asking, this is a serious hearing to revoke.
But the chair needs to rule on my motion. You don't get to tell my witness or our witness that she can speak. That is very
Okay,
inappropriate.
well, you need to, I think it's very inappropriate and unprofessional for you to be making speaking objections, leading, or
You've re-
speculation. Those are
Councils,
leading
councils. All the questions in this thing have been leading, so let's not go there. Come on.
Let's cross-examine.
Okay, well, it's an administrative proceeding as well. We don't do leading question objections in administrative proceedings, period. The chair does need to rule when there are objections, and we've let it go back and forth, and usually you guys resolved it after, discussion, but if there's an objection, the chair needs to rule before we can
You
continue.
want me to rephrase I'll strike that question. Let me ask a new one so we clear what the
Thank you,
question is.
counsel.
I don't even think anybody knows what the question is anymore.
Good with that?
Is part of the basis for, the plaintiff's attempt to revoke my client's license, the fact that somebody in the defendant's office mistakenly put this Vietnamese name down, first name is V, instead of Siam.
No, I think you're breezing over the concerns that are in this exhibit.
Okay, so it has nothing to do with the input of the name incorrectly.
It has to
Yes or
do,
no? The interruptions are very good.
yeah, if you want to
Yeah, I thought
answer,
so.
you should
Go ahead.
finish.
I'd appreciate if you answer my question with the cause for yes.
Board Member O'Brien, she has answered your question.
Okay.
You keep trying to get her to answer the question how you want it to be answered, and she has given you her answer. I'd like to move on. Thank you.
On exhibit 5, Bates number 42, regarding these same students, you received an email from my client Denise Dixon on June 30th, 2020, where she states that she'll be happy to send you weekly attendance reports for all students if you so that there is no concern or confusion. Isn't that what she offered on this page?
yes,
And on Bates number 43, it indicates that on the top there, Charlotte Williams, who's sitting right here, you were corresponding with, you had asked her for some time cards, and she cooperated and provided the time cards. And you said that they were completed, and you asked her for some additional information. At the bottom of the page, you asked if she could send a breakdown. Is that correct?
These,
On that page, that's what it says.
yes.
Anthony, thank you.
So those emails are between me and
On them.
Okay, but this, you acknowledge that my client cooperated and produced the requested documents regarding this?
Yes,
Okay, and then on the next page, number page, it's indicated that Alice Liu is just completed her application to test. So in fact, whatever issues did exist got resolved with respect to this student, and she tested and is in fact licensed today. Is that correct?
I believe these were submitted after the testing application was submitted and the staff member, Charlotte, knew to submit the documents. I do believe Alice is licensed, yes.
Okay, and then on base number 45, with respect to fee due and fee farm, my client's administrative director, Charlotte Williams, provided you the time reports, and she says, let me know if this is sufficient. Also, going forward, I can send reports as students complete. So she was showing cooperation there, wasn't she?
Yes.
And then on base number 46, Charlotte again, on behalf of my client, says, good morning, Janie. This is the time card for Thai Mu Chi Ho. She's a nail student who returned as an esthetician student. I just did a pull for 1 year. Please let me know if this is sufficient. If you would like, I can forward time cards as students complete. That shows my client cooperating once again, doesn't it?
Yes.
On March 17th of 2020, the Board of Cosmetology transitioned to remote processing. Isn't that correct? As indicated on Exhibit 6, base number 53. In response to the recent developments associated with COVID, the Board of Cosmetology and Consulting in response to recent developments associated with the COVID-19, the Board of Cosmetology, in consultation with the Nevada Governor's Office, will transition to remote processing beginning Tuesday, March 17th, 2020. Is that correct?
Yes, we were working remotely.
What type of, does the board, does your office require, what is required under the law for timekeeping records? Is it a clock in or a paper process?
It needs to be done on a device approved by the board.
And where's that statute?
It's in regulation, I believe.
Okay, and does my client's biometric finger process satisfy that requirement?
Yes.
Does the law require that my client have a paper backup for that? Does the law require?
No.
And the official timekeeping records are those in the biometrics then, correct?
There's a variety of records. We do require, since the programs are hour-based, we do require a biometric to keep track of the hours, but they're also required to keep track of what they do service-wise, curriculum-wise daily. And that usually winds up being another timekeeping document.
We could go to Exhibit 7. This issue in Exhibit 7, Exhibit 7 deals with a student by the name of April Jem Deckel, is that correct?
Yes.
And one of the issues here was that there was a clerical error and her name had an N in it that shouldn't have been in it.
I believe the major issue was that she was enrolled in the wrong program.
Okay, but so the fact that her name was that there was a clerical error and her name was input as Denkle instead of Dekle. That wasn't the big issue. The issue was that it said she was in nail, and she actually was in aesthetics.
Correct.
And and that was a clerical error?
I didn't make the error.
Okay. And April went on to get licensed and is in fact licensed, isn't she?
I believe so.
And that was in March of 2022, when this clerical error was made. Is that correct?
Yes. It was in March of 2022 that no, it was made.
Okay. And then Exhibit 8. Exhibit 8 is dealing with the advanced aesthetic program. Is that correct?
Yes.
Which used to be called the laser program.
This refers to a 75-hour course that individuals that were licensed could take to quote grandfather into a brand new license type.
Okay. And explain this first base number 71 in this. It says school owner / operator. Was this sent to all school owners?
It was only sent to the ones that were documented to have unlicensed folks take their program.
And how many schools was that?
I believe we sent this letter out to 5 of the other laser course programs.
Those 6 schools.
Total, yes.
Okay. And I just want to make sure that the board understands what occurred with my client here. Okay, so the students that my client allowed to take the advanced aesthetic 75-hour course had all completed their general aesthetics hours and had all taken the test and had all passed the test and provided my client with a screenshot that they had passed their general.
Counsel, is there a question here?
Yeah.
Okay.
Passed the test. And so they just didn't receive the piece of paper yet. Did you know that?
I believe that was the case with some of them, yes.
Well, that was the case with all of them that you're complaining about. Because you can't name one person that my client ever allowed to start that 75-hour class that hadn't already completed her 600 hours, taken the general aesthetics test, passed it, and provided my client with a screenshot. Are you?
The concern for the 75-hour laser course was that the license needed to be with them physically because there were the hands-on.
Okay, so now you can answer my question. She can read it back.
With all of them that you're complaining about, because you can't name one person that my client ever wanted to start a 75-hour class that hadn't already completed the 600 hours in the general aesthetics. Ask it and provided my client with a screenshot. Are you?
Counsel, you got to break that question up for us.
Well, I want to make sure that I just need some clarification for the board. That's all. This isn't as if my client ever allowed just Joe Blow from the street to come in and take this 75-hour class, is it? These people that she and 5 other schools were letting take this course actually had proven that they actually passed the general studies class, they just didn't have their piece of paper from the board, but they actually had passed it. Isn't that the case? I just want the board to understand, my client's just not letting just any random person take it. This should, her school and 5 other schools believed that that was okay to do if they had passed the tests. Isn't that the case with my client?
The case with the laser course was that there were strict rules in place that were voted on by the board, and we were trying to ensure that the providers adhered to them, which is the purpose of this letter. I'm sure look through all the records and find someone that was not appropriately licensed to take that course, but it would probably be true for another provider.
Well, no, because the reality is that you're suggesting that somebody wasn't licensed and there's no evidence of that. I'll move on.
Council, I'm actually gonna request a restroom break at this time.
Okay.
I'm sorry.
Board Member O'Brien, the time is 2:16. We will resume at 2:21. 5-minute break, please. All right, welcome back, everyone. The time is 2:27 on Monday, February 23rd, 2026. We are going to resume and pick up where we left off. Go ahead
Thank
when you're
you.
ready. Yep.
If we could look at Exhibit 8, please. Exhibit 8 deals with a student by the name of Maria Sanchez. Is that correct?
I have Exhibit A as the laser course information.
Exhibit, I'm sorry, Exhibit 9. On Exhibit 9, it deals with Maria Sanchez. Is that correct? A
Yes.
student by the name of Maria Sanchez. And at the top of Bates number 76, the school, it says that the school replied that they had issues and paid the fee multiple times. The response was, we don't have records of the payments and the student did not show in the system. And they were told to notify the staff immediately if this occurs again. Is this my client indicating that they were having a problem with the portal?
It sounds like it, yes.
Okay. And on Bates number page 77, at the top there, it shows that it was my client that had reached out to the school about the school's enrollment. It says January 24th, 2023, Charlotte from the school reached out about the school's enrollment. Is that correct?
You said on Bates 77?
Yes, at the top. Reading directly from the top line, January 24, 2023, Charlotte from the school reached out about the student's enrollment.
I believe that's a header from it's not the text of the email.
Okay. Was that an accurate statement?
The emails that I have, it looks like staff is sending it, but if she reached out, I'm not going to dispute that.
Okay.
I don't have that particular email in front of me.
Okay, well, on Bates number, can you go to Bates number 77 on this Exhibit 9? Because I'm reading an email that you wrote here at the bottom of the page. It's on Tuesday, January 24, 2023.
Yes.
That you wrote to Charlotte Williams, who works for my client, and it's from my client, I guess.
Yes.
It says, "Hi, Janie, these are the screenshots of these students. And when they were added and completed, Maria can't be completed because she doesn't show up on the list when we try to complete it." And it goes on to say that.
Yes, I see it.
And it's the whole issue with this student wasn't really my client's fault. It was a problem with the portal. That's my only point. Is that correct?
No, if there was a technical error, it still has to be resolved. So I'm not sure exactly when these screenshots were taken, if it was like the day of and they were looking for correction.
Okay, and they were resolved and this student is licensed now. Is that correct?
Right, you would have to re-enroll them.
So it was resolved.
Right.
Okay, and I want to talk about what you called a mold issue. My client, there was never any confirmation that there was black mold, was there? It was your suspicion that there was.
I believe she was asked to get it tested.
And she did in fact get it tested, didn't she?
I believe so.
And she remediated that issue, didn't she?
I don't know. If she did, I don't know about it, but it's possible.
Well, you're not still sending out correction notices or telling her to work on a mold problem, are you?
I would
the inspections, but I believe the issue is still there. But you're asking the wrong person essentially.
Okay. Well, you're saying that, let's see, you're saying that the staff believes as of January, the staff believes that as of June of 20th of 23, that there's a black mold problem and that the staff has allowed it to occur and relicensed her again, knowing or believing that there's a mold problem. That's your testimony under oath today?
We can't deny her a renewal. The board must deny her a renewal or do anything to discipline the license.
Well, the fact of the matter is there is no mold problem that is the subject of any current corrective action. Is that true?
Like I stated, you would be asking the wrong person by asking me. I'm not the person that dealt with that specifically.
You're the chief compliance officer, correct?
Yes,
Is there a corrective action that has not been resolved by my client currently that involves black mold?
she sent,
Yes or no?
She has to be allowed, she's been allowed the question. You cannot insist on what form she answers the question.
Well, I would like an answer first. And then
She's
she
trying to
can
give you an
explain.
answer, counsel. You're not letting her. Please allow her to answer the question. Thank you.
Black mold is not the subject of any current corrective action, is it?
I don't have that information directly. I'm going to have to ask someone else. So you'll have to wait for me to get that information.
I'll come back to it. Okay, I'll move along.
I have the answer.
Okay.
There were repairs. The inspection staff believe that it looks the same, but since OSHA told them that there was nothing we could do, we've moved on from the issue.
And what did you look at to get that answer? You
I-
just remembered it
No, I asked the staff member that deals with it specifically.
right now in the middle of your testimony?
Yes, like I told you, you're asking the wrong person.
So you're texting or emailing with somebody in the middle of your testimony? I don't think that's allowed.
She just told you that she had to ask somebody else and you didn't say a word to that.
Well, I did not realize that she was communicating with somebody in the middle of her testimony. I've never heard of anyone doing that. I would ask that that not be allowed. I don't think that if she needs to ask somebody, she can ask somebody, but that's different than texting. And I don't know what other communication she's doing on her computer. Maybe she should close her computer.
That's from the, oh, see.
Hang on. First thing I'm going to do is ask the court reporter to read back after she said she was finding out. Can you please read back the attorney's statement to Jamie when she said she needed to find out?
Pretty sure I said,
I'm looking. She said you'll have to wait. I don't have that information directly. I'm gonna have to ask someone else, so you'll have to wait for me to get that information. She said I'll come back to it when you go on. And I have the answer that okay, there were repairs.
I'm just going to ask that the chair request that the attorney like not push her when she says she doesn't know? Like she doesn't know. Like we can't keep doing this back and forth. Like
Board Member
yeah.
O'Brien, I will agree with that. I do need to just inform you, this is not a court that you might be normally
Yeah.
working in. We are more lax. So if there is something that you're asking a question on, we, the entire board staff, want to give you that information.
Yeah.
So if she does give you an answer, please accept it. But also if she is going to try to find an answer, she's not going to do anything nefarious. So if you don't want her to find the answer, I would just suggest not pushing her to give you an answer, because you pushed her to a point to say, I need to find out the answer. And that was why she went to the computer to ask to give you your answer to be helpful.
And that's helpful, and I thank you for that. If she could close her computer in that way, I don't mind.
I think she's
using it for
the
exhibits.
exhibits. Yeah.
Here,
I'm speaking, I think I'm not, okay, I'm just saying, I understand what you're saying and I can do that, and I'm glad that she found the answer, which that there's no issue with it anymore. But I just need to know, is it, from the board, is it okay in the middle of someone's testimony for them to email or communicate without anybody knowing that's going on?
Typically it is done because we
Okay.
are more relaxed, number one, and our job is to give you the answer that you're looking for. We want you to have the information when you ask a question, and we want it to be the answer that you're looking for. However, she did try to say that she was not the person. You did not respond with who is the person or ask for that information so that you could ask the proper person. So she instead tried to get you the information.
Just want to know if my client in the middle of her testimony can be emailing with other people. It sounds like she can. So
I mean,
if she needs to get an answer, she can do the same. I just want to make sure. That's not normally what happens.
Sure.
And that's all I'm asking, because I know I want to follow the proper protocol.
We understand. Yeah.
Okay.
Thank you for clarifying.
Okay.
Board Member O'Brien, I do want for the record just to state that, again, just to reiterate, this is a more laxed proceeding. So if you can take a little pressure off of our witnesses, whether it's her, anybody else in the future, we are also not going to expect the prosecutor to come at, Ms. Dixon. This is a very relaxed situation. And I just feel like things are getting elevated and people are pushed into trying to find answers when they've been answered already. So I just wanted to put that on the record again. More relaxed.
Thank you. Any of the inspections done by the staff take place during advanced aesthetics instruction time period?
I don't have the answer to that.
You know who would?
The staff that completed the inspections. Actually, I believe some of the ones that I attended had advanced aesthetics students clocked in while I was doing inspections.
Exhibit 10 shows that a citation was issued on June 23rd, 2023 for $600. Is that correct?
Multiple citations.
And that was paid?
Yeah.
Well, let me just ask you this. All citations issued to my client have been paid, correct?
I don't. Sure, I would have to
Okay,
check.
well, which ones have not been, I don't see that in the complaint, so I just need clarity on that. I don't see any citation? I mean, you don't, well, why don't we look up the end?
There's an outstanding balance of $200 owed by the school.
When was that due?
On February 7th of this year. So there are not citations that you see in the complaint.
They're not in the complaint. And what is the due date for them?
February 7th, 2026.
All the citations in the complaint have been paid?
I believe so, yes.
Are provisionally licensed instructors allowed to teach? What did you say?
Yes.
So a provisionally licensed instructor can be one of your two instructors that are there?
Yes.
LaToya? You testified about LaToya?
Yes.
She was a provisionally licensed instructor, wasn't she?
Not at the time of the inspection, no.
You're not aware of the fact that she was a provisionally licensed instructor that from another school that was in the process of transferring her provisional license to this school?
Provisional instruction license is only good for the school that you have it issued to. So if you start at school X and don't finish, it's only good for school X, which is why you need to get a new one when you start at school Y.
But LaToya, are you aware that she had a provisional license at a prior school?
Yes.
Okay, and you're also aware at the time that you went on that date that application was in process to have her be a provisionally licensed at this school?
There was not an application in process. I offered to process it for her on the spot. There was not one in the system.
And did that get processed?
There was not one in the system.
No, but eventually she got the provisional licensing?
Eventually.
Okay, thank you. Exhibit 21 deals with a boot camp. Is that correct? And I just want to make sure that our board understands this particular issue. This boot camp was offered to 15 high school students. Is that correct?
I don't know how many students in total, but it was offered to students.
And it was a one-time thing. Is that correct?
I'm not sure if it was a thing or if it occurred again.
And, but you're aware that all that happened was that the students were shadowing students in the program to see if they might want to do this one day? Are you aware that that's all that was done?
It appeared that they were doing more, but that is what we were told by niece.
Well, none of them left that boot camp with a certificate to do any by this board, is that correct?
Correct.
And and you're not aware of that ever occurring again? I mean, there are no future violation, other allegations of any violation of that, are there?
We didn't get enough information about this program to really form an opinion beyond the one individual.
Is there anywhere in the statutes that you're aware of that prohibits a licensee from letting high school students sit in and watch what's happening?
A licensee or
Either.
there are rules about,
Well, I'm talking about the school because that's what we're on.
that's what I thought. There are rules about schools offering additional courses,
Well, there
and
were-
they essentially need to be any kind of class, call it, has to be approved.
these high school students weren't in an additional course, though. They were just shadowing students that were enrolled in courses that this board approved, weren't they?
Are you testifying? I'm confused. Is that a question?
Yeah. Good question.
What was the question?
An additional course though, they were just shadowing students that were enrolled in courses that this board approved, weren't they? It appears that she was enrolled.
And of course, from the social media posts, you can see what appears to be her putting nails on, acrylic nails. She also received a certificate according to social media at the completion of this course.
Is there anything in the law that prohibits high school students from shadowing students in licensed salons that you're aware of?
We don't allow any licensee to teach any unlicensed person.
I'm shadowing.
It's a citation. You're not allowed to teach courses in cosmetology for which you don't have the appropriate licensing.
So that's all I have at this time. For this
Okay.
witness at this time.
Okay, thank you.
One second, sorry.
Yeah, take your time.
Good afternoon, Janie. Let's talk about the modifications and the workarounds for the intake system. Was this like a widespread issue, or was this just a problem for certain schools?
There was a widespread issue with all schools enrolling students in the portal, and it would only allow them to enroll one at a time. We were receiving complaints from schools about how time consuming it was to enter in one student's information, all of the school's credit card information. It used to allow them to do it in batches. I think there was also some issues just with the receipts because of the multiple credit card charges.
So it's more tedious than anything else. So like errors wouldn't be justified for not enrolling someone. That's not really a reason, like just other than it was tedious.
Correct. It was tedious and time consuming.
Can you walk me through the timeline of when you guys started seeing issues with CILV? Like when did the investigation, like when was the first time an inspector went out there, they noticed issues and that like snowballed into other issues?
For the sanitation concerns, I believe those issues were most heavy in late 3, where there were concerns about the mold popping up. There were multiple complaints about the instructors at the school, and we did have various issues at the school. In 2024, I think the primary concern that our staff had with the school was whether or not they were appropriately executing the advanced aesthetics program and curriculum. And then in 2025, after we began doing more intensive audits, we had concerns about the accuracy of the students' time records.
So 2023, was that about the time that you came on staff?
No, I was on staff prior. I took I took this position in late 2022. And one of the new leadership of the board staff's goals and directives was to start doing inspections in the school. The schools were historically not inspected by previous staff, where we kind of turned a
When you say new leadership, do you mean a new board and new executive director?
yes.
And so the executive director, did he have a mandate from the board to start going into the schools and inspecting them? Do you typically see a lot of registrars misspell names?
No, not typically.
As far as the mold rate remediation is concerned, did we request paperwork regarding that remediation? Did we ever receive that paperwork?
Some people
That evaluated it and I believe did some repairs.
Okay. What is the purpose of shadowing?
You mean with the student?
Or say I come into a cosmetology school and I shadow
To-
somebody who's cutting hair.
To learn the technique or the process, to learn from
So it
them.
would be teaching, right?
Yes.
That's all the questions I have. Turn it over to the board for their questions.
Council, if you have a recourse, you can.
No. I think that's, I'm.
Yeah. Just wanted to give you your time.
Thank you.
Okay, Board Member O'Brien. Janie, I would like to, just for the record, can you walk us through the email in Exhibit 16 that was sent out regarding the law change and just confirm that that was sent out to all schools? Or, I'm sorry, that was not. That was the, start over. Can you please tell us about Exhibit 16?
Exhibit 16 is an inspection report from an inspection that occurred on December 10th, 2024.
And this was sent to the school?
Just the school, yes.
Okay, thank you. The email that has been talked about, I've misplaced what exhibit that is. Does anyone have that offhand? What exhibit number that was sent out to the schools regarding that change for the square footage?
I'm not sure if that's in here.
Okay.
But I can tell you that I to all the were various changes coming in the regulation and
About that or more information that they could reach out to me. When we put someone in a specific role specifically to oversee the schools and deal with school-related issues, I know that that staff member also sent out additional emails and had various conversations because there were many changes relating to schools in the last regulation change.
Right. Okay. Thank you. Can you tell us in general, the schools that reached out with those issues or concerns, what action was done to get them into compliance with these new rules and regulations for the square footage?
the ones that we identified with square footage issues were directed at petitions for variances.
In all honesty, those schools that needed variances were either they had less programs, it was a smaller variance, or they were trying to take on more programs at the time that this law had changed.
Mhm.
This is something that has been just documented and discussed with Denise and her school because I believe she would need a very large variance for the square footage and all the programs.
Thank you. Can you confirm all the programs that this school offers and what that square footage would be?
I believe the square footage for all the programs that she offers would be somewhere near 18,000 square feet. Currently, this school is licensed for an instructor program, a nail technology program, an aesthetics program, advanced aesthetics, hair design, and cosmetology.
Okay.
So essentially every program.
Okay. So if we can go back to the very beginning of the exhibit 1, where you were giving the dates for the initial licensing and what they were licensed for, when did that change from just Cosmo School to all those other programs?
I'm not sure when the school formally became licensed for the nail technology and aesthetics and hair design program, but I believe it became something that was listed out on her license after she applied for and was issued an advanced aesthetics license.
Okay. 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 I wrote down, and I just was looking for you to verify or not verify, that on Exhibit 16, it was written down that they weren't in trouble. It was just that a solution needed to be found to get into compliance for the square footage, correct?
Correct.
Okay, thank you for clarifying. I'd like to jump now to the issue about the license. It is required to have a license when you are working on anyone, whether it's a class, a profession, anyone, period, at your station, in hand, present, while you're performing that service. Is it not?
Correct.
Thank you. Okay. A couple times we've heard the term clerical errors and clerical issues come up. Is this in your purview or is this someone else's job when these issues come up? Is this something that you typically oversee? Is this something else that another staff member would handle?
Some of the schools reached out with an issue with a clerical error.
Mhm.
I've assisted them if they reach out to me directly, but there's other staff members that would deal with that.
Okay, thank you. Can we just one more time state, never mind, I'm going to save that for the person who it pertains to after you've answered that question. Thank you. That's all that I have. Does anybody else have any questions? Yes, go ahead.
Hi, Board Member Will, hi Jeannie. My first question to you, In your experience with timekeeping, what is the normal process for a school and their time records when they submit them? Do they just like submit everybody and then you review it and you would send it back, or?
Typically, when a student graduates, their information is communicated to us through the portal. If we have additional questions or need additional documentation, we will reach out to the school or have the student reach out to the school to provide us with more documents about their time records.
Okay, and in this incident where there's numerous events taking place that timekeeping is not kept up and you guys went in, did corrective actions, what typically is the response from the school once you go do these trainings with them?
This is I believe this is the first school that we've offered this training to because of the issues that we've documented. We offered it to the school to hopefully correct them. Most schools don't have these issues. Just generically speaking, a lot of the schools that we license are also accredited. When you're an accredited school, you are also under the purview of your accrediting body. And those folks have to answer to their accrediting body. So they don't let these kinds of discrepancies or timekeeping issues build up.
And how often is it when you go to schools that you can't find students?
It's very uncommon.
Okay. How often do you go to schools where there's no instructor present when students are offering services to the public?
Never.
How often is it that you go out of your way, go the extra mile to offer to get somebody into compliance with the license, and they refuse?
It's very rare. We
Okay.
try to get everyone into compliance. So if we make the offer, they usually take it.
And on the day that you went to the school and there was no instructor present, what was the response of the person in charge when you asked to get the person in compliance?
Latoya didn't know that they couldn't be open without a licensed instructor. And I think there was just general confusion and chaos. They weren't really sure what they should be doing.
And when it came to advanced aesthetics, and the program was open, was that when all the equipment was locked in the room?
Yes, that equipment was locked in that room on that day, I believe.
And the way that the equipment is locked in the room, would you suggest that anyone is learning on that equipment?
No, on the day that I saw it being locked in the room, it took one of the instructors quite a while to access that room where the laser was stored, which is what caused so much concern.
And at that time, there was advanced aesthetics students enrolled
Correct.
and receiving hours
Correct.
with no access to equipment.
Correct.
And when you go to these schools and you see this equipment put away, I know there is, I don't know exact parameters, but there has to be so much equipment available to students. Was there sufficient equipment that was working or available to students at the times you were going to these inspections?
At the time that I was there on an inspection, there was a question about whether they had enough microneedling pens. I saw 3 in a locked cabinet when we found the area where they had stored them. But in complete honesty, we weren't there to count equipment that day. So if they were in another location where I didn't see that, it's completely possible.
Okay, and then in May 13th, I think I put 2025, I don't know, I exited something out. Denise stated that this was their first audit ever and that in past instances, they just needed letters of credit. So was this somewhat, I guess we could say, the culture or I guess her usual of what they do to combat students who don't have accurate acquisition of hours reported?
Yes.
And is it very common for schools to miss students' hours and to rectify it consistently with letters of credit and just say, here's a letter of credit, they were there?
No, that is not common.
And the amount of letters of credit you guys have received from the school, is it abnormal or would you say it's not very much?
They do receive a lot of letters of credit, but they are for a variety of reasons, including transferring into advanced aesthetics. They do receive a lot of letters of credit.
And then, as far as like the lack of adequate instructors available and if they were overseeing the correct, field that they were, teaching, how, the sanitation, presented very poorly. Was there people being worked on while there was insufficient instructors and,
Out of the time that I've personally been at the school, there were members of the public being worked on the date that there were no instructors present. There was a student working on another student, I believe, on one other occasion. Other than that, I've not personally observed services being done on a person or a member of the public.
and when you have been there to the school, have you seen instructors teaching and schools adequately engaged in instruction?
When I've been there, the students are typically doing something on a device.
But not interacting with each other or performing services on each other?
No, I've not seen many services be completed.
And how often do you see the teachers teaching there?
I've not gone during theory hours.
Okay, so it's always off theory. Okay, do you ever see instructors engage with students even off theory to talk about anything?
I've been there where they are present and available to answer questions, not typically during a lecture though.
And is Denise ever present during these inspections?
Denise has been present when I have been there, yes.
Okay, thank you.
Board Member O'Brien, I would like to just ask you a question about the having to re-enroll the students because they weren't done correctly. Is that a common issue with other schools as well?
No, I've not seen that be an issue very many times. I don't know what the technical issue was that caused that, but if there's no record of the payment in our system, then it means that they possibly attempted and it didn't go through, which means it was like a temporary hold almost, and nothing was permanently input into our system and the payment went away.
Okay. Can you explain kind of the process of getting that student enrolled then once you had communication with the school that had happened? What happened next?
I believe by the time that those situations that those students had been discovered, the 12 or the 14, we had implemented this workaround through a type form where you are no longer inputting things directly into our school portal. It was a type form like any other application that we have. I think the concern with that was there was a technical error or whatever the case may be that caused that those students were not enrolled despite the school thinking they were enrolled. We agreed that no violations would be issued for them going beyond the 30-day timeframe that's set in regulation. And then we had to ask again to ensure that they were getting enrolled.
Okay. Were these students trying to test at this time, or was this something that you had found before the testing period?
I think this was prior to them needing to test.
Okay. Okay, thank you.
Board Member Wold, sorry, I had one more question. How often is it that people are asking the school to get initial documentation? I saw on some of the exhibits that no one ever got like an ID or just like very just normal documents you would give to someone when you sign up. How often does that occur when documents that are supposed to be initially submitted aren't submitted until it's time to test?
I don't believe that's very common because a school or a registrar is supposed to collect certain documents upon enrolling them. Whether or not they've provided them to us at that time they don't always have to provide them, but there is a part in our regulation that says that they obtained a copy of their identification, their age, their birth certificate, their high school status, whether they completed or graduated. So they all should have it. It's something that we have started to audit them on in the most recent years.
And what was the attitude and the response you guys got from all this timekeeping training that you offered CILB?
I personally have not had many issues with attitude or being difficult, but I know that other staff members have had difficulties with the staff trying to request documents, have conversations, or ask questions.
And do you feel that after all the documentation of students who are missing hours, hours that are incomplete, hours that don't align, do you feel that they decided to follow the training you guys provided?
No.
And do you feel that if things were to continue, that they would make any adjustments since we are here today?
I don't think that there would be meaningful adjustments. There have been some improvements over time, but the reason for the so many exhibits and so much documentation going all the way back to 2019 is showing this has been a systemic problem with the records and the issues that have been occurring in the school.
And from the students not being there, showing back up whenever clocked in on the clock, instructors coming and going, no one wanting to talk to board staff, treating you guys with that you are the operating authority, having jurisdiction, from, people not answering about the beauty boot camp, who's this, who's that. Do you feel that this is the culture of the school?
Yes.
Do you feel that their standards are, if you're here, just clock in and leave and then come back and it's not a big deal?
I've gotten that impression, yes.
And would you say that do you feel that the students that are coming out of the school are adequately learning and adequately being taught?
I have concerns that they are not being adequately taught.
Yeah. And then have you seen any students performing? I know you guys did like an impromptu sanitation mock go through. Do you feel that they were receiving that, or were they just doing it since the board was there?
It is hard to say if they were receiving it or if they were doing it to go along with what the board staff was saying.
Thank you so much.
Thank you.
Remember O'Brien, Janie, these issues that you noticed with CILV, when you've seen these issues in the past and they've come about, is it usually an indication of something bigger?
Yes.
Okay. I do have a question regarding, can you elaborate on what the issue is with backdating or logging a student hours for all completion, all of that? What is the issue with that?
All of those timeframes are dictated in laws and regulations. So that just calls for compliance with that time frame. But there is a concern if you aren't keeping records in real time with the students' records and their timekeeping in their curriculum, that they won't be accurate.
Thank you. Board members, do we have any other questions for this witness?
No, ma'am.
Okay, I think.
Board Member Douglas, I don't. You guys asked all the questions I was thinking about asking anyway. Thank you.
Thank you, Board Member Douglas. All right.
I'd like to call Jackson testify.
Thank you.
Oh, I need
Can
Where?
While you do that, I'll do the oath. Bertha, can you please raise your right hand? Do you solemnly swear the testimony you're about to give in this matter is the truth and nothing but the truth?
I do.
Thank you.
Good afternoon, Bertha. Could you please say your name and job title for the record?
Jackson, Chief Operating Officer.
Bertha, how long have you worked for the board?
I believe it's going on 11 years.
What are your duties as Chief Operating Officer?
I supervise the licensing department as well as operations for the board.
Are you familiar with the board's records related to student eligibility to test? Is part of your job reviewing student records to decide if someone can test? Please turn to Exhibit 27. I'm just gonna wait. Will you please walk us through Exhibit 27?
Yes, this is the student record for student ST 831, Yariser Magaya. This first slide is the transcript that we received from the school that noted a few discrepancies and issues that were of concern. On this transcript, it shows theory as 102 hours with a grade of 102. Infection control, 66 hours with a grade of 110. Same with electrotherapy, lasers, devices. They have 222 hours with 113%. Field trips, 20 hours with 133% for the grade. On this next slide, it is the violations of NAC 644A, 642, subsection 4B, where the student attends the school for not more than 10 regular scheduled work hours in any day. And these are all the dates that are listed where the student was working more than 10 hours. And then a few of the examples for those dates. The next slide is violation NAC 644A 6.642, subsection 1. Take one mandatory 30-minute lunch break recess for every 7 hours of training. In this, it again lists all the dates in which this particular student did not clock in a lunch or did not clock in a full 30-minute lunch break. And then there's a list of examples as well. The next slide is violation NAC 644A.642, subsection 1, where the student is required to take one mandatory 30-minute lunch recess for every 7 hours of training time. And in this slide, the dates are listed of all the dates where the student did not clock in a lunch break for more than 7 hours of training time. The next slide is the total findings. In this slide, we found 54 total days where discrepancies were found between the clock-in hours and the performance sheets. 31 days where the time cards showed more than the performance sheet times that were listed on there. And then 23 days where the time card showed less time than the performance sheets. The differences ranged from 5 minutes to up to 59 minutes. The next slide is the performance sheets. This slide shows one student, which is student A, that was enrolled in the same program, and student B, which was Yariser, enrolled in the same program on the same date. And they show two different performance sheet total hours for each subject. So for example, sanitation and infection control on student A is 60 hours, but sanitation on Yariser's is 50 hours. And then it goes through on the next slide. It lists all the differences on there where there's just a clear discrepancy in which performance sheet is being used and for each student for the same program. The next slide, week 5 and week 4 are listed on here. Week 5 shows electrotherapy. It shows a different performance sheet. It's the same student. One week has a different performance sheet than the following week. So it made it very difficult for us to track how many hours were actually being taught in each subject because one had makeup application and the other one did not. The next slide is an example of where it shows the student was clocked in for 7 hours and 38 minutes on Thursday, April 10th, 2025. But the totals for this day were 7 hours, so there's 38 minutes unaccounted for. For week 4, on the next slide, the totals for this week for theory were 10 hours, not 11, so the total was not correct, making the grand total 39 and not 40. The totals for this week should be 38, not 39 hours. The grand total should be 129 and not 130. Week 5, this is where the performance sheet changed from the B version to the A version. The 3 hours for makeup application for week 3 can't be tracked using the version of this week's performance sheet, which again made it very difficult to determine or track what is being taught at the school. This is also missing carryover hours for some of the subjects. Modeling list 0 required, but has 2 hours for this week. So if they're not required on there, they're listed as 0. Why are they being input on this sheet for 2? On the next sheet, there are, so this is we had 2 sheets for week 5. One of them's blank with hours under this week's total, carryover hours and grand total, but there's nothing listed on there for each subject. But there's another week 5 with different totals as well. And that's on the following sheet or the following slide, which again makes it difficult for us to determine what hours are being taught under which subject. Week 7 has the 3 hours for makeup application for week 3 can't be tracked using this version of this week's performance sheet. The student was clocked in for 5 hours and 16 minutes on Thursday, 5/15/25. Totals for this week, totals for this day are listed as 5 hours. So again, there's 16 minutes unaccounted for. The grand total hours don't add up correctly with the if you're taking into consideration the carryover hours. Week 8, similar discrepancies on this week where the total hours that are clocked in don't match what is listed. And the carryover hours are also incorrect, and the grand total hours are incorrect. On this slide, the modeling lists 0 hours required, but the student completed 4 hours this week. On this week, same issues as the prior week. For the next slide for week 10, similar issues. Similar issues on week 11. Same with week 12. Week 13. All the way through, same issues with up to week 21, 22, 23, same with week 24, week 25, week 26, and up to week 27. Same issues on this slide for week 26. It has been noted that on September 30th, 2025, the initials listed under instructor initials were of the owner, Denise Dixon, but she is not a licensed instructor. On this week, there was also a note at the bottom of this sheet where it said 814 or 820.02. Same issues with week 28, week 29. Week 29, there is a date listed on here where the student's initials were missing from this performance sheet. So we're unable to determine if the student actually completed those 2.5 hours earned on that day. The next slide is the practical final results form. These exam forms must be graded using a full points only, as stated on the directions to add only the circled numbers in each column. Partial points are not accepted. The total score for microcurrent segment was 42.5, which is an unacceptable score. The photocopies were a little light, so we were unable to determine if this was an exam or if it was a retake. The program title is also not clearly visible. The next segment, 2, for facial peels, the tasks were not circled. There was an arrow drawn in different directions. Certain tasks were marked with an X. Again, it was inconsistent grading methods on this slide. The next slide for segment 3, microcurrents. Practical exams again must be graded using a full point system. And again, they earned a 42.5. Half points cannot be accepted as an actual grade. The section can only be graded as a 3 points or 0 points. The next slide is page 11 from the Practical Skills Exam Manual given to all the schools. A score sheet form is required for each segment. This form requires the examiner to circle the points gained, not cross them out. If the student tests across multiple days, multiple forms must be used in this case. Only the service segments tested on the date must be filled in. All other service segments on the score sheet must be stricken or crossed out. If a student passes all service segments in one day, the students will have the score sheet in each service segment of each category. The next slide is the field trip discrepancies. For this, the school stated that they were not aware of the board field trip policies. School states that they created the field trip sign-in sheets, which is on slide 14, after the date of the actual field trip. This is an email that staff received on November 7th, 2025, where it states, I have attached an example of that work. Also, I was instructed to explain the field trip form. Our campus did not learn about the field trip protocol until our most recent encounter with the state board in September. Attached below is a document that was recently created to reflect those who attended the IBS convention with Miss Iris. Let me know if you have any other questions. Thank you. So that email was received from the school where it states that they went back and created a document months after a field trip was taken. On those documents that were created, it has listed all the student names that attended, and we can't determine what dates these were on because they all say June 21 through the 23rd of 2025. And it doesn't show that this document shows that all the handwriting is the same. So it doesn't show that the student actually signed themselves in, signed themselves out for a lunch, signed themselves back in for a lunch, and then out for the rest of the day. But again, going back to the email that it was created by the school. The next slide for exam discrepancies show this student took an exam on September 4th, 2025. There's no final score. And then there's like a highlighted section on this score sheet that says, can't find this one. We were unable to determine if this student passed this exam or not. Theory coursework discrepancies. This was a photo that was provided for proof of the theory coursework. We're unable to determine if the student created those posters, what the date was of that coursework. One photo of coursework is not equivalent to coursework for the entire program. No additional coursework was provided. And then there was an email. It says the students are given worksheets and textbooks to highlight and fill out for their own benefit of studying. They are also given group projects to complete. It is done on campus and on the walls of the classrooms. Those assignments are offered at the discretion of the instructor. I have attached an example of that work. Also, I was instructed, that goes into the field trips. Attendance discrepancies. On September 4th, 2025, the Compliance Department conducted an inspection of CILV. During the inspection, the regulatory compliance specialist was unable to find a few students and had to speak to various staff at CILV to confirm their attendance. Staff cross-checked the records for one of those missing students who was this student, Yari Ser. The compliance staff were at the school from approximately 3 p.m. to 4 p.m. The regulatory compliance specialist checked with Charlotte, Denise, and Iris about the student. Iris stated that she recalled seeing the student. However, the student could not be found or accounted for during our time there by CILV staff or board staff. It appears that her performance sheet states that she was signed off by Elise. All of our time records in our possession conflict with the records provided by CILV. The student sign-in sheet that was photographed around 3:30 p.m. does not show Yari Ser's name. The time records that were printed at the school around 3:30 p.m. show her last punch being at 12:15 p.m., but her final records indicate that the punches for lunch occurred at 12 to 12:30. The sign-in sheet supplied by the school showed her signing in and out during the time frame that we were at the school, but her time records do not reflect those. Here's a few examples where it does the daily sign-in sheet does not show her name on there. On the you attend, it shows it shows that the student clocked out at 12:15 during the 3 to 4 p.m. visit of the state board office staff. Her clock in shows that she was there from 8:09 a.m., clocked out for lunch at 12 p.m., clocked back in at 12:30 p.m., and then clocked out at 6:30 p.m., again during the time that she was not found at the school by board staff. On her performance sheet, it shows that she initialed at the end of her instruction for that day for a total of 9 hours. And again, with Elise signing off on that day's instruction at the end of the day, according to this performance sheet that says instructor signatures required in ink after each performance daily. Again, during the time that she was not found at the school. And then another daily sign-in sheet for that date where it shows Yari Sir's name, signing in, signing out for lunch, signing out and in for lunch, signing out and in for her break, and then signing out for the day. It is to be noted that her break is listed as being 3 o'clock to 4:30, which is not the typical 15-minute break that you would take at a school. since she already had clocked in a lunch for that day. And then the final sheet for her shows her denial letter, where it states that there is multiple discrepancies found throughout her application on one or more of the following school documents. Due to those discrepancies, we were unable to approve her for testing. And if she wished, she could have a reconsideration by petitioning to appear before our board. And that was sent on December 11th, 2025. For the next student, Sonia Laro, her enrollment discrepancies show the first picture is of her application where she states she enrolled in May of 2025. The second photo is the transcript that shows that she enrolled 6/3/2025. Enrollment agreement with a date of 5/20/25. And then the term on her enrollment agreement was 5/20/25 to 11/18/2025. So all just different start dates. On the next slide were discrepancies found with her transcript and the performance sheets. The first one is the hours required according to the performance sheet, the hours completed according to the transcript. The next one is the total hours calculated from the performance sheet over the 21-week period using the sheet that was found in the student's file on 11/12/2025 by board staff. And then the discrepancies found with a total hours calculated from the performance sheet over the 21-week period if using the final sheet that was submitted by the school on 10/17/2025. Each of these have different hours. So one performance sheet shows that the student has a total of 828 hours. That was found on the November 12th, 2025 inspection. And then the performance sheet that was submitted by the school shows that there's 819.5 hours, showing again discrepancies, making this unreliable. On the time card discrepancies, we have the student date listed on her transcript of 6/3/2025, but she's clocked in for hours prior to that start date, May 20th, 21st, 22nd, 23rd, 24th, 27th, and 28th of 2025. The next slide is violations of the NAC 644A.642, subsection 1. Take one mandatory 30-minute lunch break for every 7 hours of training. This shows all the dates listed, similar to those of Yarisers, the previous student, where it showed that she did not clock out for lunch. The next one is a violation of NAC 644A.642, subsection 1, where they're required to take a mandatory 30-minute lunch break for every 30 minutes of training. On these instances or these dates listed, the student didn't take the full 30-minute break. The next one is violation 644A.642, subsection 4B. Attend school for not more than 10 regular scheduled hours in any day. And this lists several dates where the student was clocked in for more than 10 hours. The next slide is the findings. 46 total day level discrepancies between the records, between the time cards and performance sheets. 30 days where time cards showed more time than the performance sheets. 16 days where the time cards show less than the performance sheets. And the differences range between 1 minute to 49 minutes. Discrepancy between documents found on site by board staff when compared to the documents sent via email from the school on the following dates: 10/6/2025, 10/7/2025, and 10/10/2025. The next is a breakdown of the performance sheets. This one shows that no hours were earned on 5/28/2025. Totals for this week were listed under field trips, but no supporting documentation was provided. The student was clocked in for 8 hours and 1 minute that day. Totals for this week are 8 for theory and not 10. 24 for facials and not 30. So they, again, did not add up. Similar clock-in discrepancies on week 4. Also noted that the student was clocked in on 6/13/25. For 5 hours, but was not, but listed 8 hours of instruction that day. There's also on this document, the initials from the student for Thursday and Saturday are missing. Monday, 6/16/2025 shows that the student completed 24 hours for field trip, which is over the 15 required. And again, there's no supporting documentation. And this one shows that 24 hours of field trips were earned in a 24-hour day. And then we cannot determine what subjects were taught on the Saturday. It lists 8 hours, but it's not listed under what subject. Week 6, we can't determine what subject the 8 hours were earned for Monday, 6/23/2025. Saturday, 6/28/2025, the student was clocked in for 7 hours and 33 minutes, but 8 hours of credit were given on that day or listed for instruction on that day. And then similar, where it's difficult to determine what is being taught this week, and under what subject and what the total hours are. A note at the top of week 7 states that the student left at 11:30, but the time card shows that they clocked out at 12. Total for Thursday was Thursday 7/3/2025 is actually 2.5 and not 3.5. And then the hours on 7/3, the student was clocked in for 8 hours and not the 2.5 that was listed. The next sheet just shows that the student's initials were missing on that day of instruction for July 9th, 2025. On week 11, 1 hour earned in modeling on Friday, 8/1/2025, but modeling is not a subject listed on the official transcript from the school. On week 12, total of for theory hours for this week were not 14, they were actually 13. Same with facial treatment and advanced procedures. The total was 23 and not 21. The time card also shows that the student was clocked in for 8 hours both Friday and Saturday, August 15th, 2025 and August 16th, 2025, but no hours were listed on the performance sheet for those days, and the initials were also missing from the instructor and the student. The totals for theory hours for this week were not 20, they were actually 16. Again, going with that the totals aren't being added up correctly. There were 8 hours earned on Saturday, 8/23/2025, but no hours listed on the performance sheet, and no subjects. We can't determine what was taught that day. Initials are also missing from the instructor and the student that day. On this sheet, same with the hours not totaling the correct amount. This one, it does show that this sheet shows that the student has carryover hours and field trips of 2 hours and a grand total of 2 hours. But we can't determine the actual hours earned for field trips because the performance sheets show 8 hours earned on 6/21/2025. Or sorry, 6/16/2025, 6/21/25, 6/22/25, and 6/23/25. But the field trip hours total is listed as 7 on the transcript. Week 16, the total for facial treatment and advanced procedures is actually 23 hours and not 26. Total hours for chemical exfoliation and dermaplaning are blank on this sheet. The total hours for state board procedures are blank also on the sheet. Same with week 17. Week 18 shows instruction on Friday, 9/19/2025, of 9 hours, but she was clocked in for 10 hours and 24 minutes, leaving an hour and 24 minutes unaccounted for. Same with the totals not adding up. The time card also shows for Monday on 9/15/2025 shows the student clocked in for 8 hours, but no hours listed on the sheet, no initials from the student or the instructor. On the next slide, hours being earned on Monday, again, not listed on this performance sheet, no initials from the instructor or the student. There is a note on this sheet that says homework hours 8, but homework is not listed as a subject for this performance sheet. And it's my knowledge that there's no schools that give hours for homework. Week 20, total of theory hours are left blank, but there was hours earned that week. Same with facial treatments and advanced procedures. Total hours for this week are actually a total of 34 and not 45. Student was not clocked in for Monday, September 29th, but performance sheet reflects 5 hours earned on that day. The performance sheet shows the following hours earned: 4.5 on 9/30/25, 5 hours on 10/1/25, 9.5 hours on 10/2/25. The student actually clocked in 10 hours and 9 minutes on 9/30/25, 9 hours and 49 minutes on 10/1/25, 8 hours and 24 minutes on 10/2/25. Week 21 on this slide, this is what was found in the student's file at the school and scanned by board staff. This performance sheet is missing the student's name, so we're unable to determine if this was actually the student or not. And this week's also missing the instructor initials, going against what is listed on this performance sheet from the school that says instructor signature required in ink after each performance daily. Student was not clocked in on 10/8/25 and 10/9/25. The grand total hours for theory are 256, which is 156 more than the required 100 hours listed. Grand total hours for facial treatment, advanced procedures are 427, which is 302 hours more than the required 125. The next slide is the same week 21, which was provided by the school via email on 10/17/25, which shows different hours listed under carryover and grand total. This performance sheet shows the following hours earned were 6 hours on 10/6/25, 5 hours on 10/7/25, 4 hours on 10/8/25, 4 hours on 10/9/25. The student actually clocked in the following hours: 9:50, 9.50 hours on 10/6/25, 9:46 on 10/7/25, and again not clocked in on 10/8/25 and not clocked in on 10/9/25. The next slide is showing the week 20 discrepancies, internal mismatch leading to the major inconsistencies. Week 20 shows weekly hours is 0, entered for every subject line on the sheet. Despite 0 weekly entries, the sheet reflects carryover hours of 236 in theory, 413 in facial treatments, and 2 hours under electrotherapy and laser devices. Week 21 conflicts with those 2 different performance sheets. Week 21 performance sheet found in the student file in November 12th, 2025. It shows theory being 20 hours earned that week with a carryover of 236 and a grand total of 256. Facial treatment and advanced procedures, 12 hours earned that week with carryover of 415 hours and grand total shown of 427 hours. All other categories were blank, indicating 0 hours recorded for those subjects. Yet on week 21, on the performance sheet that was emailed by the school to the board on 10/17/25, it displays different and much lower grand totals. The sheet is incompatible with the established student record. These hours don't align with prior running totals. Going into practical exam score sheets and discrepancies. On this segment 1, LED facial treatments, the total of circled numbers add up to 27 and not 34. The exam was marked with a passing score, but the total does not meet the passing score. Next slide, segment 2 for facial peels. The candidate 1 was listed on the exam score sheet was Sonia, no last name, but the full name was listed on the retake. The total of circled number adds up to 27 and not 31, since you can't give half points for number 18 on this segment. The retake total of circled numbers adds up to 22 and not 35. Number 13, 14, 15, 16, and 17 were marked with a line through them. They were not circled as required in the instructions on the practical score sheet. The exam was marked with a passing score, but the total does not meet the passing score. Segment 3, microcurrent. Similar discrepancies where the totals of circle numbers add up to 27 and not 31. 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 13, 14, 15, and 16 were marked with a line through them. They were not circled as required in the instructions on the practical score sheet. The exam was marked as a passing score, but the total does not meet the passing score. Segment 4, ultrasonic treatment. Total adds up to 20 and not 33, since you can't give half points for number 16. 20 would not be a passing score, and she would need to retake this part of the practical exam. Number 13, 14, 15, 17, and 18 were marked with a line through them. They were not circled as required in the instructions on the practical score sheet. Even if we did accept them, the total is still 32 and not a passing score. The exam was marked as passing score, but the total does not meet the passing score. The next slide is the similar slide that we saw with Yariser, where it gives instructions on the grading system and that it's required that the examiner circle the points gained. The next segment is blood exposure. The candidate's name is missing from this score sheet, so we are unable to determine if candidate 1 or candidate 8 was our actual student. The next slide is the final results exam. The scores documented in the final results form do not match the scores from the individual exam segment score sheets. Exam scores documented as passed when the individual exam segment score sheets do not total and do not meet the passing score. Field trip discrepancies. The school provided the email and the badge attached as the only proof that the school retains for the student attending IBS. The email and badge do not confirm the date of the event. Performance sheets show 8 hours on 6/16/25, 8 hours on 6/21/25, 8 hours on 6/22/25, and 8 hours on 6/23/25 for a total of 32 hours. Yet the transcript showed field trip hours total listed as 7 hours. The next slide, again, is similar to the one we saw with Yariser, where the school stated they were not aware of the board field trip policies when providing documents for another student. Upon review of the attached documents, board staff located Sonia Laro's name included on the sign-in sheet. School states they created the field trip sign-in sheet after the date of the actual field trip. Next slide is the same slide that we saw with Yariser, where the handwriting is different and we can't determine which date each document is from, since it just gives us a time frame from June 21, 2025 to June 23, 2025. And again, these were created on 10/30/2025 by the school. Exam discrepancies. The following discrepancies were present on multiple exams. We're unable to confirm the actual final exam score due to question marks with one or more of the answers. We're unable to determine if incorrect answers were provided. It's just an inconsistent grading method. And then the final score is missing as well on the bottom of this. Similar discrepancies on the next two examples. And theory coursework discrepancies for this student. For this student, we did receive something different. Missing theory grade record sheet for this student. I apologize. This is just an example of what was provided on a previous student. This was missing on this student's account. So again, we were unable to determine what they earned in theory coursework. The next one, practical senior hours checklist discrepancies. For this student, she did provide a checklist that was used to track her completed practical learning. Multiple dates show that they've been altered by being written over in a different color pen. For example, July 7th to August 8th. Check marks are inconsistently marked throughout the document. Blank subject is listed for 0.5 hours at the on the end of this document, but we don't know what those hours should fall under in order to give proper credit. 200 hours of business plan is dated 10/3/2025, but we're unable to coordinate the total with any hours on the transcripts or performance sheets. Pro 60 facial with skin analysis galvanic on 8/2/25. She completed 1 hour, but she wasn't clocked in according to her time cards that day, and no hours were listed on her performance sheet that day. Microneedling treatments on 8/27/25. She completed 2 hours, but no hours were listed for microneedling services according to her performance sheets for that day. Bikini wax underarm on 8/27/25. She completed 0.25 hours in bikini wax, 0.25 hours and completed 0.25 hours in underarm wax. No hours were listed for hair removal services according to her performance sheets for that day. Half leg wax on 8/29/25 completed 0.5 hours. No hours were listed under hair removal services according to the performance sheets for that day. Same with eyebrow wax on 9/4/2025. And tattoo removal on 10/1/2025. The denial letter is on the next slide that was issued to the student on December 2nd, or to the graduate on December 2nd, 2025, letting her know that her application has been denied. And we are unable to approve her for testing based on discrepancies found with the following documents. She has the option to petition to have her application reconsidered by the board. The next one is Angelina Pullman Medina.
Board Member O'Brien, the time is 4:04. We are going to take a short break. 5 minutes, 5 minutes. Let's come back at 4:09. Okay, welcome back to Nevada State Board of Cosmetology. The time is 4:12 on Monday, February 23rd, 2026. We are going to jump back in. Bertha, if you'd like to continue.
Bertha Jackson for the record.
Oh, good. Okay.
We are on Angelina Pullman Medina. The next slide shows her enrollment discrepancies. There were 2 contracts provided by the school. The original contract signed 8/31/2024 and an amended contract signed 6/17/2025. Only one enrollment fee was paid by the school on 9/26/2024. The student took a leave of absence from July 29th, 2025 to August 26th, 2025. If the student withdrew from the program, this was never submitted to the board. A letter of credit was never issued to re-enroll the student when the contract was amended. And here's the original contract and the leave of absence. The next slide is the transcript discrepancies, where the total amount of hours are listed. The salon management hours are listed as 15 with a grade of 60. Reception desk, 11 hours with a grade of 44%. Modeling, 19 hours with a grade of 48, which are not passing scores. And then the total program hours earned on this are 604, which does not match the performance sheet totals. The hours completed per subject on the transcript are actually total up to 576, coming under the required 600 hours for aesthetics. On this transcript, it should be noted that it states that Cosmetology Institute of Las Vegas is NACA's accredited school. The school CILV is not accredited or a candidate for accreditation at the time that we reviewed this transcript. On this slide, it does show the required hours listed per subject, the hours completed per subject on the transcript, which total 576 hours, the total hours from the final performance sheet on for week 31 that was submitted by the school, those total 604.43 hours, and the actual calculated hours by board staff using those 31 weeks of performance sheets with the total of 607 hours. For this one, the time card discrepancies, again, going with violation NAC 644A.642, subsection 1, where they're required to take a mandatory 30-minute lunch for every 7 hours earned. Listed are the dates that they did not clock out for lunch. The next slide shows a violation of NAC 644A.642, subsection 4A. Attend to school for not more than 40 regular scheduled school hours in each week. Listed are 3 weeks where the student clocked in over 40 hours, one being 45 hours and 4 minutes, week 28. Week 29 is 49 hours and 44 minutes. Week 30 is 50 hours and 7 minutes. Next slide is violation of NAC 644A.642, subsection 4B. Attend a school for not more than 10 regular scheduled school hours in any day. Listed are the dates that the student was clocked in for over 10 hours. Performance sheet discrepancies, week 1. The student was clocked in for 4 hours on 9/3/24, 3 hours and 48 minutes on 9/4/24, but 4.5 hours are listed on those dates according to the performance sheet. 4 hours and 28 minutes on 9/6/24, but 4 hours listed on that performance sheet, leaving 28 minutes unaccounted for. 6 hours and 41 minutes on 9/7/2024, but 8 hours listed for this day, showing roughly about an hour and 20 minutes of no instruction. Clocked hours for this week were 18 hours and 57 minutes, but 21 hours are listed as completed this week. Similar discrepancies with week 2, week 5, week 6, week 7. Week 9, there was no performance sheet for this week, and we can't determine what was taught on this day since it was missing, but the student was clocked in for 4 hours and 25 minutes that day on November 12th, 2024. Similar discrepancies with week 12, where the theory carryover hours from the previous week, number 11, were 64, but are listed as 62. Carryover hours were incorrect, and grand total hours are incorrect. Similar discrepancies with week 13, week 14. Week 15, there were 2 week 15s in the student's file. The first copy, copy A, shows carryover hours adding up to 145.5. Listed was 147.5, but the actual total, according to all the performance sheets, was up to week 15 was 168.5. Carryover hours on the second copy of week 15 show a discrepancy of 166.5, which is different than copy A that shows 145.5. The listed hours are different as well, with 168.5 being listed on copy B, and the actual being, again, 168.5 for this week. Grand total hours, again, are different with copy A and copy B. Copy A adds up to 166, listed 168, and actual 189. Copy B adds up to 187. It's listed as 189, and it's actually 189. Theory carryover from the previous week was listed as 77.5, but on here they're listed as 69.5 for this week. Carryover hours were incorrect, and again, there's no identifying week number on these sheets. Here's a continuation of week 15, where there's 2 week 15s. We are missing instructor initials for that Friday. The carryover hours again are incorrect, as well as the grand total hours. We can't determine the instructor that was teaching that week due to another student's performance sheet that showed a completely different instructor initialing for that same week. Week 16, the student was clocked in for 8 hours on 6/23/24, 8 hours on 6/24/25, but 0 hours listed on this performance sheet. Instructor initials and student initials are missing. The student was clocked in for 6 hours and 46 minutes on 6/26/25, but 7 hours are listed for that day. Clocked in hours for this week were 35 hours and 9 minutes. 19.5 hours were listed as completed this week. Carryover hours are incorrect. Grand total hours are incorrect. And no identifying week number listed on this performance sheet. It's important to note that even if the week identifying number is not listed on it, we're going by the date that's listed on these performance sheets. Week 17 has similar discrepancies. Week 18 has similar discrepancies. Week 19, week 20. Week 21, we are missing the performance sheet for this week. Can't determine what was taught on July 30th, 2025 for 5 hours and 52 minutes. Same with week 22, we were missing a performance sheet for this week, and we could not determine what was taught on 8/13/2025 for 4 hours and 37 minutes. Week 23 has similar discrepancies with the total hours listed, the total that these hours add up to under carryover and grand total, and what the actual hours are. Similar discrepancies with week 24. Week 25 is similar. This week, the student clocked in hours were 24 hours and 5 minutes, but this sheet shows 16.25 were earned. Similar discrepancies again with the carryover hours and the grand total hours on week 26. Week 27, similar hours with clock in times versus what's listed, and the carryover hours are incorrect as well as grand total hours are incorrect. Similar discrepancies with week 28. Similar discrepancies with week 29. Same discrepancies with week 30. Week 31, similar discrepancies. On this sheet, it's important to know that the student was clocked in on 10/24/2025. They clocked in at 8:13 a.m., clocked out for lunch at 12:12 p.m., and then clocked back in at 1:56 p.m., but never clocked out. Yet there's 3 hours and 59 minutes earned on that day. For this student, 41 individual day level discrepancies were identified where clock in times don't match the recorded daily hours on the performance sheet. 23 hours contain incorrect or missing weekly totals, carryover hours or grand total hours. At least 5 weeks contain missing instructor initials. The clock in total hours for this student was 650 hours and 59 minutes, but we can only account for 607 according to those performance sheets. The practical discrepancies. There is no exam completion date listed on this score sheet. The score sheet is missing. There's score sheets missing for the student for basic setup, eyebrow wax, facial, and blood exposure. So we can't verify what those individual scores were. Theory coursework discrepancies. Theory coursework documents were not provided by the school upon request, and we were unable to verify or review those missing documents. Listed is a sample of the letter that was sent to the student on January 15, 2026, letting her know that her application was denied because there was discrepancies found with one or more of the following school documents. If she would like to have her application reconsidered, she could submit a petition to appear before the board.
But I do have a couple questions. Going back to the portal for a second. Actually, no. On the week 15 duplicates, on page number 001055. Have you ever seen that before where there's 2 time cards for the same week?
In the time I've been here, no.
Never seen it.
No.
Going to the portal for a second, because I know you had a lot of input on those changes. What changes did you implement? Let me repeat the question. So going back to the portal for a second, there were some changes implemented after there were some issues with doing them individually. What procedures did you put in place for those changes?
About the enrollments, student enrollments. So we ended up the process throughout my time working for the board. The enrollments changed. I wasn't familiar with the process prior to it changing in 2016 when I first started. I can only speak to the system that we use now, which is NV Cosmo and the school portal through NV Cosmo, where the instructors are to submit all the information. They submit the student individually, submit the payment, and it goes from there. We recently implemented an enrollment change to that due to the payments not coming through right before April of 2025. For that, we changed that process. April 22nd, 2025 was when we first started receiving that. Those enrollments are submitted through Typeform. The school selects, the school registrar selects which school the student is attending. So if there's an issue with them submitting an enrollment for a student and there's an issue with what school they were attending, and if it's not that school's, I don't know if I'm making myself clear with that, but let's say I'm a registrar with school A and I submit an enrollment for a student and I select school B, that's not on the board. That we're just going off of what the registrar is submitting. If they selected the wrong school, that is what we're going off of. But we try to catch those issues and reach out to the registrar because it does let us know who the registrar is in that form. We try to reach out to the school to get those corrected because we end up having to manually input that in, but we're putting it in based off of the information that's provided on those type forms.
Really quick, I just want to clear one thing up. Can you turn to Exhibit 29 on page 001105? I think it's 29. Yeah, keep going. Keep going. One back. Can you read the top for me real quick?
Your description?
Yeah.
Intentional failure to maintain adequate records. Statute 422.570.1. Gross misdemeanor. Date 1/5/2015.
Okay. And so gross misdemeanors do not need to be disclosed for any type of license that.
That is correct.
Okay. Going back to the records for a second. How would you cure those records? Like, is there a process I mean, other than going before the board, like how would a student convince the board that they did the proper amount of hours, that they, passed their exams?
It's difficult to say because you can't go back and correct a record that's already been submitted. You can't, there just would be no way of, I mean, since we requested those documents, the school is letting us know this is the proof that we have that the student attended when they attended. This is what they studied or what was taught by which instructor. And if there's discrepancies with that, it's difficult for us to say, well, prove to me that you were actually there that day when the school already submitted documents saying you weren't there. It's difficult if you as the student are not keeping track of your hours, adding them up correctly. That makes it difficult for us to track. How are you going to go back? How would you go back and show proof that you actually did the total amount of hours when the school documents are showing something different? They're showing that you didn't complete the total amount of hours.
So you'd essentially have to make up the hours. Is that what I'm understanding?
Unless yes, you would have to falsify a document in order to prove that. I mean, there's just no way to prove that you actually did if there's already been documents submitted.
You're saying in the alternative to actually going back to school and
Correct.
And
if you were to say, I'm not going to go back and make up hours, I'm telling you that the original hours that I did are correct. Prove to me that they're correct. Well, I did by submitting what the school submitted. Unless you have a magic document that says, here's all the proof, why is it that the school didn't submit that already?
So in your opinion, as somebody who looks at these records all day, how would you characterize these records?
It's unreliable. I can't verify any of the documents that were submitted. It's difficult.
Thank you, Bertha. Those are all my questions for now. I turn it over to opposing counsel.
I don't.
Okay.
It's our turn. Do we have questions for Bertha? You already answered my question, so all right, I think we're good. Any questions for board members that are on the call for Bertha at this time? I don't think so. Okay.
No, I don't have any.
Okay.
I'm the prosecution rise for now.
I'm sorry, what did you say?
I have no more witnesses to call, so I'm turning it over to you.
Okay, so I guess maybe at this time we should talk time and figure out the game plan.
Okay.
Because it says it's 5:35.
4:35.
4:35. And I feel like it's a little late to start with the defendant in this case today. Because we're clearly not going to finish her. And I would rather the board be fresh, the witness be fresh, everybody be fresh. And I can't stay late tonight because I have a flight out to the East Coast. So I would ask that we reconvene on the soonest possible date that everybody can be here, that you can get the notice out. And I don't think it will take all that. I mean, it's not going to take this long, but I just think it's too late to start.
No, okay. Since we're on the
her fingers if she keeps typing.
Since we're on the record though, are you going to call anybody else other than, because we haven't really talked. We basically met this morning.
And I can talk as well.
Absolutely.
Maybe we can resolve something which might be good too, but yeah. And then we can talk about what additional witness. I think I would probably be calling a couple of my witness. I might be calling a couple of these people to explain certain things that have been discussed. And but they would be very short witnesses. The long witnesses, this one.
I mean, I took up most of the day.
I mean, I think it would be good to reconvene, let us try to talk in the meantime, get it noticed up properly. And in the meantime, you and I and perhaps the executive director can talk and figure out if there's a possible resolution. And if so, then we could do that. Because my goal, my client is to try to resolve this without shutting down. And, but she clearly has some things that need work on and help, and she wants help.
Madam Chair, it's my recommendation at this time that we kind of end the proceeding today with the purpose of coming back at a later date and time to be determined. Yeah.
Okay. I do have a question. We do have a March 9th meeting date. How is that going to be affected?
Yeah, I'm not board counsel.
Yes, Madam President, Steve McDonald for the record. You're absolutely right. There is a March 9th meeting. We've already done the open meeting law requirements, so that agenda is done. We do have our next regularly scheduled quarterly meeting is April 13th. So I'm sorry, you guys are not going to keep getting sick of me. I'll be bringing another meeting to complete this unless we resolve this matter. But right now, tentatively, we're looking between after March 9th, so March 10th to in between up to the April 13th quarterly meeting. So we'll look at dates to see whether we can get a quorum and with the board members, and we'll go from there. But as opposing counsel just said, there may be, we'll call it opportunities that could be possibly resolve this
And
matter.
just to confirm, you don't foresee any issues having this continued after, or I'm sorry, taking the March 9th meeting before finishing this?
Steve McDonald for the record. No, Madam Chair.
Okay.
It's just the other half
Okay.
of the proceeding.
Okay.
We'll be fine.
Can I just ask a question so that I follow the rules?
Sorry.
I do think we want the opportunity to try to work with them. I don't know if it's allowed for who I'm allowed to talk to.
We could.
I mean, whether he and I can talk with you on the phone.
No, it would
or-
be. I would have to be there. I mean, we could meet even to. What time do you have to go? 5?
It's not, I'm on a later flight. It's a long day, but I'll be flying all night. But I do have time to sit here after
We could.
and talk to you guys if that's okay. I mean,
That'd be fine.
okay, because he and I had a great conversation in the hall and just, you know,
Oh.
we volleyball,
Yeah,
volleyball,
yeah.
our kids, yeah.
Military.
So, yeah, the bottom line is we want to try to resolve it and it would
Absolutely.
benefit everybody if we can. So let's talk.
Okay. Absolutely.
Okay.
I'm open to that.
Okay, then at this time, we're going to adjourn for the day. The time is 4:40. Sorry. Yep. Are we still in a meeting? Sorry. Okay, hold please. I have to go through all my notes. Okay. Okay, moving on with agenda item 5, comments from the general public for discussion only. The board will entertain comments. Yes, I'm sorry, I caught myself. Okay, the board will entertain comments from the general public for any item that is related to the Nevada State Board of Cosmetology. Members of the public can call into the meeting to make public comments by dialing 1-720-707-2699 and entering 893-8557-0576 for the meeting ID. Comments are limited to 3 minutes or less. No discussion or action can be taken during public comment. Do we have any public comment at this time? Yes. We just need to get your first name, last name, and then come up. We just need your first name and last name up on the podium with the microphone. Yes, thank you. Thank you.
My name is Sonia Lauro. First of all, I would like to thank Miss Denise for giving a lot of people, students, an opportunity to change their lives, make a decent living, and the contributions she made to all those people that are now working and making a living to feed their kids, because most of them really don't have anything. So I was thankful for that. And that would be a great contribution that she made to the society for those that are not be able to do the studying. If they can't go to NEMA, they can't go to other school, Euphoria, the tuition fee that we paid really reflects a minimum amount of help that she could get. And as far as the time clock, I'm one of the people that I would say that time clock doesn't work. I am there in the whole time that I was enrolled. And when I saw my time clock at 11:57, I never go to school at that time. There are mistakes that are being made, yes, but I think there are honest mistakes or maybe the lack of help that is needed. But like some of the things are not well explained, and we didn't know what is required, not required, what to do. And when we were denied to take the exam, we've been calling, let us know what we have to do from October to December 2nd. I've been calling, let me know. I'm getting so stressed out because I didn't miss the school. But yet the time clock, when they're broken, I think they don't or forgot to do the time that we put in. Because I don't know how many times during the time that I was there, the clock is not working. Oh, we'll just, put you in. But I guess that was forgotten at the end of the day. So I would like to make sure that it's not for me, okay, whatever the board wants me to do, I will willingly do it. Because I put all that time with no absent. And whatever the board decide, I will do it. But I just want to be, I just want to ask you guys to be lenient for those other students that are now there. Make sure that if the punch out is not correct, is there any reason why the punch out is not correct? Maybe the time clock is not working. And most of the time, if it's not working, a lot of students will be not punch in. So we'll be missing those hours at that time. So I just want to make sure that's looked upon because I, for once, never clock in at 11:57. And so that's all I want, lenient to those students that are now there because most of them needs to make a living. And I ask of you to be lenient to them.
Thank you.
Some of the students, we have to contribute to get their supplies. So I, for once, have to sponsor one of the students to get the supply. So I just ask of you to be lenient. Miss Denise, there's so much
Thank
people
you.
that don't speak English. So it's hard.
Thank you. Thank you for coming. Are there any other people that would like to make a public comment at this time? Okay, I think that concludes public comment. Let's go on to agenda item 6, comments from board members for discussion only. The board will entertain comments from board members for any item that is or is not on the published agenda and is related to the Nevada State Board of Cosmetology. No action can be taken on a matter unless it is included in an agenda. Comments should be limited to 3 minutes or less. Do we have any board member comment at this time? No? Okay. All right. Now I will call for adjournment at 4:46 p.m. on February 23rd, 2026. I hope everyone has a nice day. Thank you.
Thanks.